Professor Stoughton's testimony is not relevant.
I think that's what he's testifying about. So,
His opinions are not relevant.
okay. Okay. Maybe you've made your argument, so appreciate it, or your objection. All right. Anything else, Mr. Bordula? Before the jurors come in?
No, Your Honor.
Okay. We'll have them come on back in. Welcome back, and you may be seated. Sorry for that extended break. Everybody call your next witness. And I'll remind you that you're still under oath.
Yes, sir.
Still under oath, but just for the jury's benefit, since you weren't here for the first time, we kind of went through this. Could you state your name and spell it for the record?
My name is Seth Stoughton, S-E-T-H-S-T-O-U-G-H-T-O-N.
Could you tell the jury what you do for a living?
I'm a professor of law at the University of South Carolina, Joseph F. Rice School of Law, and the faculty director of the Excellence in Policing and Public Safety program there.
I guess I could split that up. Could you tell the jury how long you've been just purely a law professor at the University of South Carolina?
I'm just finishing my 11th year there.
And knew that you get the whole title in the policing aspect of it. What is that, and how long have you been the head of that?
The Excellence in Policing and Public Safety program is about 2 years old now. I've been the faculty director the entire time. It's a legislatively funded program in South Carolina to help provide training, professional development, and research and technical assistance to police agencies in South Carolina and beyond. We spent the last 2 years doing training of groups of police executives in South Carolina. In August, we will launch the country's first master's degree at a law school specific to public safety executive leadership.
Now, when you talk about training executive leadership for the police department, what is executive leadership defined as?
When we're talking about police executives, we're really talking about what's often referred to as command staff members. Exactly what that rank is will depend from agency to agency. At a very large agency, that might be captains or majors and deputy chiefs and a chief. At a much smaller agency, it might include sergeants or something like that. But if you think in terms of rank and file officers and sort of middle management, anything above middle management is really what we refer to as police executives or command staff.
Now, you're saying this is only 2 years old. Could you give a little bit of background? How did this get started? Why did it get started?
Sure. So I and some other folks that I work with at the University of South Carolina wanted to look for ways that we could bring academic resources at a top-tier research university to local policing. We already had pretty good relationships with local agencies on an individual basis. I do a lot of work with specific agencies, either assisting them with research needs or asking them to assist me with research needs. But we wanted to do something to sort of institutionalize and formalize that. In South Carolina, there is no executive level training, no professional development for police officers. We end up sending our police executives out of state to programs like the FBI's National Academy, and we wanted to develop some in-state capacity for that to help support the state and the community. So those discussions started about 4 years ago. We spent about 2 years putting together proposals and sort of refining what exactly we would be doing before getting the initial block of legislative funding in, I guess it was October of 22, and really launching in operations in January of 23.
And so you've been part of that process since the inception, working, who else are you working with? Is it just purely the university, or is it other entities in the state of South Carolina?
We have an advisory board that's made up of about 60 or 70% South Carolina law enforcement.
I'm going to object, Your Honor, developments of his knowledge of South Carolina law.
Nothing to do with South Carolina law. It's who he's, this police training agency covers not just South Carolina, but other places.
So you're just asking him for background information?
Correct.
At this time?
I'm not asking an opinion on anything, it's just background information of what this is all about.
Okay, you said what this is all about.
The police training facility that he's starting up.
Okay. And Mr.
The
Ford?
relevance of him setting up a police training facility in South Carolina is not relevant to this matter, Your Honor.
Lays a foundation as an expert in this area if he's going to be talking about police practices.
Well, I mean, I would tend to agree as far as getting into detail about it, but the fact that he's setting something up is fine.
Okay.
So I guess I'm partially sustaining based on whatever the next question. You can answer that question.
The question I had, or the question,
What was the question that you just asked?
just in terms of what was the purpose of setting this all up? What was the purpose of setting this
Oh,
up?
then I'll just sustain the objection.
Could you go a little bit of your educational background?
Sure. Let's see, in chronological order, went to high school in South Florida, went to Florida State for undergrad. I'm a little slower than the average bear, so it took me 10 years to get a 4-year degree. I went from there to the University of Virginia for law school, and that's it for formal education.
Okay. Now, in terms of after graduating the University of Virginia Law School, did you become a law professor right away?
No, not right away. I spent a year clerking, working for a judge. I was set to go back to a law firm in Charlottesville, but had the opportunity to do what's called an academic fellowship. The academic fellowship is really designed to help prepare you for entry-level legal teaching, to learn to be a law professor. It's kind of like a postdoc, but for JDs, for lawyers. So I did that for 2 years and then went on the entry-level market and was hired at the University of South Carolina.
Now, at the University of South Carolina, specifically, what do you teach there?
Within the JD program for law students, I teach criminal law, which is our first year required criminal law course. I teach a course on criminal procedure, which is fourth and fifth and a little bit of the Sixth Amendment. I teach a class called Police Law and Policy. I teach a class called Regulation of Vice, seminar really. I have taught some other classes, but those are sort of my current teaching package.
Do you do something with the undergrad facility as well?
I have a courtesy appointment within the Department of Criminology, so I'll go over and lecture in coworkers or colleagues' classes. I have taught an undergrad version of my Regulation of Vice seminar with our honors college, but I have no real normal teaching responsibilities at the undergrad.
Now, in terms of your experience within teaching criminal law, criminal justice, and policing, have you done any sort of publications? Have you wrote any books, articles, anything along those lines in the field of criminal justice, criminal law, or policing?
Yes, that is the other half. I have about 4 different halves of my job. One of those halves is academic research and publication. Articles, essays, book chapters, 1 book so far, and the occasional other professional writings, editorials or amicus briefs and the like.
What is the 1 book so far that you've authored?
It's very creatively called Evaluating Police Uses of Force.
Now, in terms of, you say people ask you to write book chapters then for their own books, can you describe that a little bit more? What does that mean?
Sure. So there are academic books that are written by a single author that follow a sort of arguments or series of arguments. There are other academic books that are edited volumes of collected chapters where every chapter is written by a different author presenting something about whatever the overall topic is. So I've done book chapters on in a book about sort of law generally. My focus was on law relating to police misconduct around the world. I've done book chapters on evaluating police use of force incidents, on review and evaluation of police use of force incidents, on evidence-based policing and its applicability in modern policing, a range of topics.
And now, in terms of that, in terms of a lot on policing, do you have any experience in policing yourself, separate from your academic kind of credentials, any practical experience in policing?
I do, yes. I spent 5 years, just under 5 years, as a full-time officer with the Tallahassee Police Department in Florida, and then another 6 months or so as a reserve officer, a part-time officer at the same agency.
Do you do anything, I guess, currently, taken away from your new entity, do you do anything currently with any police agencies or police departments through your work in the law school, or as a professor, or involved in that any way in any other police departments, if you will?
Not including through the policing program
Correct.
that I run. So not including through the policing program, I will occasionally be asked to come in and do training or to lecture on a particular topic. Once once I was asked to formally come in and investigate and review a use of force for not actually by the agency, but by the city council of this city involving this agency. I'll be asked to come and speak in training that an agency offers not only to its own officers but to other agencies. So the Washington, D.C. Metropolitan Police Department has a police leadership academy. It's a 3-week program, I think, and I come in and talk about use of force review for 1 afternoon in that course. In a couple of weeks, I'm going down to Charleston, South Carolina, where the Charleston Police Department has its own police leadership academy, both for its own officers and officers in the area. So I'm sort of guest lecturing as one of the talking heads in that program. None of which is formally through the policing program that I run.
So those are your people are asking you to do that, and then a lot out in South Carolina. Is that just in South Carolina, or do you go across the country doing that as well?
Sort of where asked, as long as my schedule works out. I've done it in D.C. twice, Kansas City, back to D.C. for a different agency, Charleston previous, and that's in South Carolina, kind of wherever time and schedule allow.
Do you belong to any groups, any outside organizations in terms of involved in policing and police review institutes? For example, the American Law Institute.
I do. I am a member of the American Law Institute. I was an advisor on a project of the American Law Institute called Principles of the Law Policing that actually just got released in final form after about 8 years of working on it. I am a member of the the American Society of Evidence-Based Policing, the International Association of Chiefs of Police, and the Legal Officers section. I think I still have an active membership in the Police Executive Research Forum. think that might be it for police-specific organizations.
Now, in terms of your work, you're outside kind of law professor, do you get hired, brought in to review use of force incidents involving police officers in specific cases like this one?
Yes, I do.
Can you give the jury an idea how many times you've been asked to do a review similar to the one you did here?
I've been formally retained 130 or 140 times, somewhere around there. I can't even count. I do not keep a track of how many conversations that I have that may not lead to retention, so there are some number of other phone calls or emails or exchange beyond those where I do not end up getting retained for whatever reason. Most of those are litigation related, either civil or criminal litigation, a combination of plaintiff side or civil defense or prosecution or criminal defense. There are some non-litigation retentions where it's sort of strictly a consulting capacity, usually as a subject matter expert through a federal grant, a Bureau of Justice Assistance grant or something like that.
Have you testified then as an expert in any of those cases that you've been retained on?
Yes, I have.
How many times have you testified in a courtroom like this?
In court, in trial, somewhere in the area of 24, 20, 24, maybe a little bit more than that. Deposition testimony is even more than that. I don't know off the top of my head, probably twice as often.
And in those instances you testified, you've been qualified as an expert in use of force and police practices?
Yes, I have.
I'd move for this time to have him introduce his testimony, introduced as an expert in use of force and police tactics, or police practices, excuse me.
No objection?
Not to those areas, Your Honor.
All right, so he shall be considered an expert in those fields.
Can you give the jury an idea of approximately when did you get involved in this case and what goes into getting involved? What did you review when asked to review a police use of force case like this one?
Yes, you're asking me the hard question, which is about timeline. I don't even remember the timeline that I got involved. I could try and look at my retention agreement, that would remind me, but it would be right around there. So I don't advertise as an expert. I don't have a website or business cards. I basically get emails or phone calls from other folks who have passed my name around. I forget if the initial contact here was an email or a phone call, but it was one of those things that asked to set up a conversation about whether I could be potentially useful in this case.
Now, in terms of when you decide to take on a case, what is your process? What do you do? What do you look at?
So the first and most important thing that I look at is whether I am an appropriate expert in the case. There's a lot in policing. There's a fair amount in policing where I wouldn't want to be testifying about technical expertise in an area that is not covered by my research or experience. With tactics and use of force, those cases are pretty sound. That's well within my wheelhouse. Sometimes with other cases, that's an easy way for me to weed out retentions. Probably the next thing is looking at my schedule and making sure that I can do the work that needs to be done in the timeline that it needs to be done on. And sometimes that will involve a preliminary review where I look at maybe 20 minutes of worth of material, a short video or something like that. We did not do that in this case, as I recall. I think we had a preliminary discussion and then engagement, and then I'd actually start the review. I get the body of material that is shared with me and start the review process.
Now, before we get into it a little bit more, you talk about tactics and use of force being kind of in your wheelhouse. Could you describe to the jury what you mean by, first off, what are tactics? What are tactics that are in your wheelhouse? What do you mean by that?
Sure. In the policing context, tactics are how officers navigate and mitigate potentially risky situations. It's the decisions, the procedures that officers use to help keep themselves safe, and because they are safer, the community members that they're interacting with are also safer. There are a couple of different definitions of tactics, but they all come down to making a decision to balance competing priorities in a way that allows officers to achieve whatever the police mission is in that individual interaction in the safest manner that the situation allows. There are a bunch of different kinds of tactics. I'm sure we can get into some of that, but sort of as an overview, tactics are just how officers manage risk and prevent risk from escalating to the point of being a threat, or a threat from becoming a full-blown actual injury or harm of some type.
And what about the use of force? You kind of separate that out. What does use of force mean to you in this aspect?
Yeah, in the way that I'm using that term, use of force is really about the application of coercive physical force. So the easy one is shooting someone, punching someone. Sometimes you'll get some different definitions where use of force might be just communication. When I'm talking about use of force, I'm talking about hands-on physical engagement with someone, either with weapons or without weapons, the use of coercive physical force.
Now, when you talk, then we start getting into, you take a look at all the materials when you're reviewing a case. Can you give the jury an idea of what materials you reviewed when looking at this case and what occurred here?
Sure. At a very high level, there were 3 videos. There was a dash cam, a body cam, and a bystander cell phone camera. There was an investigation and documents related to an investigation. There were some agency policies and procedures, some training documents. I can probably get more detailed if needed, but that's an overall summary.
And so you take a look at, you get all that together. Now, in this instance, I also want to clarify, this was kind of a joint report with Nick Bloomfield, correct?
It was, yes.
How do you do a joint report? How is that different? Is that something you normally do?
It's not common, but it's not uncommon either. I've had a couple of cases now where I've done a joint report with another expert. The process does not really change at all. The only thing that changes is after we review the materials and develop opinions, is coming together and make sure that the report that we submit has opinions that we both agree to, and that we don't have any internal points of disagreement that would require an addendum or additional reporting indicating our points of disagreement.
So for the jury's benefit, you get a look at the body cams, you get all the materials, the investigative materials. Could you give them an idea, what do you look for? Okay, what is going through your mind in terms of reviewing a force? You know, what happened here? What criteria do you use, I guess?
Sure. So the first thing is I have to know what actually happened, right? So the first thing that I do is review the materials to get an understanding of the facts. It's a little simplistic to say I watch the videos and read the reports. It's a little bit more like I watch the videos, I read the reports, and I compare them to each other to identify points of consistency or inconsistency, to identify where there are still lingering questions that the body of evidence doesn't actually solve, to identify discrepancies or issues where 2 different witnesses might say 2 different things, right? As an expert, it's not my job to figure out who was telling the truth or figure out which discrepancy is accurate, or which piece of evidence in a discrepancy is accurate or inaccurate. So normally what I do in cases like that is I just make note of this discrepancy and say, hey, there is, this person said X, this person said not X, right? Said something different. Once I have an understanding of the facts, then I try Gesundheit. Then I try and identify what the different decision points were. That is, where an officer made a decision. And as you can imagine, there might be dozens of those decisions that an officer makes over the course of an encounter, right? With each decision, I'm looking at the decision to see whether the decision, and that might be a tactical decision, it might be an enforcement decision, like do I stop this person and chat with them or not? It might be a use of force decision. What I'm looking at is whether that decision was consistent or inconsistent with generally accepted principles and practices in policing. Does it meet that sort of professional degree of commonality that we expect professional officers to be able to meet?
Can you go into that a little bit more? What exactly is generally accepted police practices, and what does that mean to you and for the jury's benefit?
Sure. Again, this is a little little colloquial, but when we're talking about generally accepted principles and practices, and I can define those two things separately, if you went to a reasonably well-trained officer at any agency, pretty much anywhere in the country, and you said, is this more or less the way you do things? If they say, yeah, that's more or less the way we do things, that's probably a generally accepted practice or generally accepted principle. This is a little bit tricky in policing because we don't have a single authoritative body in policing that sets out what generally accepted principles and practices are, right? In accounting, there's something called the generally accepted accounting principles, and all accountants have to use that. We don't have that in policing. We have about 18,000 different police agencies across the country, some very, very small, some very, very large. So when we're trying to identify generally accepted principles or practices, we're asking what has sort of bubbled up from below. What do all of these agencies, what do officers do? What is common and generally accepted as the standard for professional policing across agencies? You can find information about generally accepted practices reflected in an agency's policy manual. You can find it in statements or publications by police organizations like the International Association of Chiefs of Police, or the Police Executive Research Forum, or the National Police Foundation. But it's not authoritative because the International Association of Chiefs of Police said it. It's easier to flip that and say the reason that the International Association of Chiefs of Police is saying that in something like a national consensus policy or national consensus paper on use of force is because it is so common that it is generally accepted.
Now, can you get into a little bit in terms of what factors do you consider when you're looking at an incident? What are the factors as an expert you consider when reviewing tacticals or police use of force? What are some of the factors taking into account everything?
The ultimate question for tactics when I'm reviewing them is really what are the tactical risks of what the officer is doing and what is the benefit of what the officer is doing, right? Officers, as one resource puts it, officers work in risk soup. They're constantly in situations that are dynamic and maybe uncertain. So they have to make this series of decisions without fully accurate information. So what risks do they take? And what risks do we say those are not professionally appropriate risks anymore? As that phrasing sounds like, it's very, very heavily fact dependent, right? There are situations that will absolutely justify officers putting themselves in grave harm, like an active shooter situation where we now train officers to run in and identify that active shooter to deal with the situation. There are other situations where that degree of risk-taking would be inappropriate or unjustified, right? Where we don't want officers to unnecessarily take risks. And the way we determine whether an officer is taking a risk appropriately, professionally, or unnecessarily is by basically looking at what's the tactical risk, what's the tactical benefit, putting those two things together, does it make sense? When I'm answering that question of does it make sense, that's not me as, Seth thinking, do I think this makes sense? That's where looking at generally accepted practices, looking at generally accepted principles across policing, applying that framework. Does policing as an industry, does policing as a profession think that this is a professionally appropriate risk or not a professionally appropriate risk?
Now, you touched on it a little bit in terms of running into active shooters. What role does the threat against the officer play? Does that play a role in any of your analysis?
Yes, it plays a huge role, particularly as we shift from sort of the tactical question to a use of force analysis. So when we're analyzing use of force, we're again looking to see what the officer is trying to accomplish, but there's a slightly different framework for that. So officers can use force to deal with imminent threats, and I can define that term in a second. But when they have a situation that does not yet amount to a threat, but might still become dangerous, it's a potential threat, that's what we refer to as risk. So as sort of a rule of thumb, officers use tactics to navigate risk. They use force to address threats. And in policing, a threat exists when the individual that the officer is interacting with has the ability, the opportunity, and the apparent intention to cause some kind of harm to the officer or others. I can define those terms if it's useful.
I guess you could, because you talk about imminent threat. What you said, imminent, is that the definition of imminent threat then, in terms of the ability and so forth?
In policing, it is, yes. You will sometimes hear immediate instead of imminent. You will hear some commentators sort of distinguish between those two things. For my purposes and most experts, the important part is there an imminent threat? And an imminent threat exists, or if you like, a threat is imminent and thus justifies a use of force when the subject has the ability, opportunity, and intention to do something, right? At that point, there is a threat of something that may justify a use of force.
Can you go a little bit more detail? What is the difference between imminent, or what is an imminent threat, and maybe something that's just concerning?
Sure. Yeah. So really this focus on ability, opportunity, and intention. Again, I don't want to get too like carried away with specific language, because it's really the concepts more than the words. Sometimes you'll hear ability, opportunity, and jeopardy, or you'll hear ability, opportunity, and threat, or some combination, but it all kind of means the same thing. When we're talking about ability, we mean the physical capacity to cause whatever type of harm we're talking about, right? If an officer is interacting with someone who doesn't have anything in their hands, then that person might have the physical ability to hit an officer with a fist, but doesn't at that point have a physical ability to swing a weapon, as opposed to someone who's holding a tire iron. Now that person has the physical ability, the capacity to hit the officer with a tire iron. When we talk about opportunity, we're really talking about, is anyone vulnerable to that particular type of harm? If someone has that tire iron and they have the physical ability, but they're 60 feet away, they don't have any opportunity to hit anyone. They might if they get closer, but they don't yet. On the other hand, if they're within arm's reach of an officer, there is ability and there is opportunity to now use that tire iron as a weapon. The last prong is apparent intention. Does it look like the person is trying to do that thing, right? From the officer's perspective, does it look like the person is going to do that harmful act? So someone who has a tire iron that's within arm's reach of an officer, but they're chit-chatting on the side of the road while the guy changes a tire, might be a situation of risk. The officer could say, sir, why don't you put that tire iron down? Or the officer could back away and use distance as a tactical concept. Or the officer could interpose a vehicle between himself and the subject. But there's no threat because the subject doesn't look like they have the intention to use the tire iron as a weapon, as opposed to someone who is swinging the tire iron at the officer or cocking back as if to swing the tire iron at the officer. At that point, we have ability, opportunity, and intention, which means we have a threat that justifies the use of force.
And so that use of force, it covers the spectrum in terms of, could be throwing a punch all the way up to deadly force. It's kind of the same analysis then?
It's exactly the same analysis. We're still looking for an imminent threat of something. And that's really important because there's no such thing as a threat. It's always a threat of something, a threat of escape, a threat of being injured, a threat of being seriously injured or killed or something like that. What's different with different types of force is the next sort of question. If there is an imminent threat such that some use of force is justified, then we ask, okay, what kind of force would be justified here? If it's a very high-level threat, it tends to justify a higher-level force. If it's a very low-level threat, then it justifies a very low-level force. In my world, this is referred to as proportionality, right? The use of the use of force has to be proportional to the threat. So the way that we do this analysis is first asking, what is the nature and severity of the officer's use of force? Then asking, what is the nature and severity of the threat that the subject presented, if any? And then once we answer those two questions, we weigh them against each other and identify the relationship between them to determine whether, as a matter of generally accepted principles or practices, policing would define that as proportional or not.
And in terms of, there's a reasonableness figure into that. Is that proportional? Is reasonableness and proportional the same thing, or is reasonableness a little bit different? Do you use that differently?
It's effectively the same thing. Policing has adopted into its generally accepted principles the term reasonableness, which ultimately it sources from law, both Fourth Amendment law and state common law decisions. Incidentally, that's also where concepts of ability, opportunity, and intention come from. Those ultimately originate in common law doctrines related to assault, but policing as an industry has accepted those as the practices and principles within policing.
So when you look at using the term reasonableness, does reasonableness come into play? You talked about intent, a motive, and opportunity with a person the force is used against. Does reasonableness pertain to the officer then more? Is that, do you use that distinction, if you will?
Yes, I am looking at applying this framework. That is a framework that we use to analyze an officer's decision making, right? Is the officer reasonable? Is the officer consistent or inconsistent with generally accepted practices? We have other frameworks to assess the other person, right? We might ask, did the other person commit a crime, for example, by doing whatever they did to the officer? But the frameworks that I'm talking about, and my role as an expert, I'm analyzing police actions, not subject actions.
So I guess getting kind of to the meat now in terms of looking at this incident specifically. Did you come to any conclusions in terms of different types of actions that were taken by the defendant during this interaction with Patrick?
Yes, I did.
I guess starting off the first thing, I guess, starting off with, what happened at the beginning. What were your conclusions?
So again, I'm looking at all of the decisions that were made. The sort of initiating decision here, the first level decision is the decision to stop the car, to initiate a traffic stop. Generally accepted in policing that when officers have reason to believe that there is a traffic infraction, that you can stop a car. My understanding is that there was an improperly displayed license plate on the car. That's a traffic infraction. So stopping a car for that reason is consistent with generally accepted principles and practices in policing.
So a reasonable officer in that circumstance would have done the same thing.
Yes.
What about your next analysis?
I believe the next opinion related to Officer Schurr's attempt to grab Patrick after he got out of the car and began to walk away. That use of physical grabbing, it's a use of force. It's a relatively low-level use of force. Comparing, again, the nature and severity of the officer's use of force, which is relatively low risk. That is, when we're identifying nature and severity of force, we're really looking at what is foreseeably likely to happen, and just grabbing someone is not foreseeably likely to do very much, so it's a fairly low-level use of force. Nature and severity of the threat that Patrick's actions presented there, he's walking away, there's a threat of escape or evasion, so balancing those two things together, grabbing someone who's attempting to walk away is perfectly consistent with generally accepted principles and practices in policing.
So a reasonable officer in the same circumstance would have done that?
Sure.
What about the decision to chase him around the car? What about that?
That's where we start to run into issues. So they run around the back of Patrick's vehicle and then past the front of the vehicle, sort of along the sidewalk into that driveway area. This creates some tactical concerns, and the reason it creates some tactical concerns is because there is another individual in that car. And in policing, the goal is not just catch whoever runs away, the goal is to do so safely and efficiently. And if you run past a car, you don't know what else is going on with that individual in the car, what else they may be doing with any evidence that might be in that car. So if one person goes hightailing off and you chase them, you may miss the fact that the other person is taking all of the evidence out of the car and walking away and dumping it somewhere. You also expose yourself to some unnecessary tactical risks. When you run past the car and now you have the other individual in the car at your back, you have no idea what they're doing because you're so focused on the individual that you're chasing. And that gives them an opportunity to, put it bluntly, get out of the car and attack you in a direction that you were not expecting. So going back to that sort of tactical framework, the tactical benefits of chasing someone are not nothing, right? There is some tactical benefit that I could chase someone and maybe grab them. But the tactical risks of doing so are substantial. And for that reason, there's generally accepted guidance in policing that says if there are more people in the car and someone goes running, you stay with the car. There's a pretty good chance that you're going to be able to identify whoever ran by talking to the people in the car. That gives you the opportunity to collect any evidence in the car. And if you can identify them and collect evidence by talking to the people in the car, you just get a warrant and catch them later. Doesn't mean they get away scot-free. You just may get them, later that day or tomorrow or something.
Now, when you say generally accepted police practice, specifically on foot pursuits, what is there anything, a background, if you will? What sort of things are you relying on to say that is a tactically bad decision?
Sure.
For the officer?
Yeah, so there's now a lot of guidance on foot pursuits, including from the International Association of Chiefs of Police, the Department of Justice, and others that have pointed out that foot pursuits are an indication not just that someone is trying to escape, but that someone is more likely to resist at the end of that foot pursuit. If they're already running, they may try and push you off of them. Or they may even be, direct violent or assaultive action toward the officer with their attempt to escape. So because of that reason, even ignoring someone else in the car, the general guidance in policing is that when you are chasing someone on your own, you do not actually want to catch them until you have another officer present, right? You want to keep them in sight until there are additional officers on scene so that, to put it bluntly, so it's not a fair fight, right? You don't want it to be a fair fight one-on-one. You want the officers to outnumber the person that they are attempting to take into custody. When you add other people in, and like the person sitting in the car, again, there are tactical considerations beyond just catch the person who is running, like the ones that we mentioned. So the International Association of Chiefs of Police, for example, reminds officers that they have to consider that totality of the circumstances, including other people who may be running or who may not be running, but may choose to involve themselves in the scuffle after that.
So then, look, kind of the next step, and I wanted to, because Nick's going to testify tomorrow, or maybe later in the day, depending on how things go. I want to kind of go over skip over the taser, leave that for him.
Sure.
In terms of following up the next aspect. Did you have an opportunity to take a look at Graham's police policies and procedures as part of your analysis of all this?
Yes, it did.
I'm going to show you what's been entered into evidence as Exhibit 32. You recognize that?
I do.
And in terms of that document, that's one of the documents you reviewed as part of your analysis of this case.
Yes.
I think maybe it's the second or third page on that. There's a policy changes, if you will, 2020 policy changes.
Yes.
Got on page 3 or 4? Can't remember.
Policy changes is on page 4 here.
Okay.
I don't mean to interject, but the exhibit we have, to match what the professor is. Can I get a copy of exhibit 32?
Would you like to look at it?
Yeah. Just a kind of confusion. Thank you, Ryan, sorry.
Reach the right spot.
Thank you.
So the 2020, there are some changes, I guess, in terms of 2020 in regards to police, specifically Grand Rapids Police policies and procedures, correct?
Yes, that page says GRPD at the very top. GRPD use of force policy changes 2020.
Now, in terms of the policy changes, was there any direction in terms of giving a warning before using deadly force?
There is, this is number 3. Number 3 says require a warning before shooting, and then goes on MOP 9-1.64 Whenever reasonably possible, officers shall provide verbal directives before deadly force is used.
Now, in terms of, you knew that, did that factor into your analysis in terms of when you're trying to make a decision on the use of force, the ultimate use of force, which you're called in for in this case, did that play a role in your decision?
Sure, yeah. In sort of two ways, right? One, everything that I looked at factors in, right? Everything in the case file factors into the decision making, even if it ends up not being dispositive. In this particular case, one of the opinions that Nick and I developed after reviewing the materials is it would have been feasible in this case to give a specific warning about the use of deadly force prior to that use of force.
And why is that?
Why was it feasible, or why is that? Because there was time to do so. There are at least several seconds prior, even while Officer Schurr is reaching for and drawing his gun, that would have allowed for a specific warning about the use of deadly force.
Now, in terms of that, you've talked about generally acceptable police practices. Does that also, this policy also reflect that, if you will, in terms of, is that something that's required now, or at least across the country?
It does, yes. So it is certainly a generally accepted practice now that officers give a warning, and I want to emphasize when feasible, because the situation does not always allow for it, but that officers give a warning when a warning is feasible, when it is reasonably possible to give a warning. It's generally accepted in policing that they should give a warning prior to using deadly force. That actually got incorporated into generally accepted police practices after a Supreme Court decision in 1985 that sort of made the same point. Now, that was in a legal context, but police practices adopted it as a generally accepted principle or practice within policing.
Now going into a little bit and further in terms of, I guess I'll go right here. Can I use the, some of the stuff that we're introducing are procedures by the GRPD. We don't want to put those on for the media. These are policies that are already out there in the open, so I'll refer directly to them. This is still part of Exhibit 32.
Sure.
We're looking at 9-1.1. Since you're here, looking at paragraph 3. Do you see paragraph 3?
I do, yes.
And this would be the use of force policy, if you will, for Grand Rapids Police.
Yes.
And you reviewed that?
I did.
What are your thoughts? As an expert, is this generally what's out there for other departments? Is this sufficient? Can you give an idea how this factored into your decision?
So this is a pretty casebook reflection of generally accepted practices in policing. Policing limits the use of deadly force to those situations where there's an imminent threat of death or great bodily harm. Policing typically says that there are two ways that can happen. One is immediate, one is through escape, and you see both of them sort of outlined in B3 there. Again, the wording might be ever so slightly different, reasonable threat instead of imminent threat, but the concept is certainly is reflective of generally accepted practices in policing.
Going down now to this is 9.14. I don't want to shrink it too much. You can see it just a little bit at the top. 9-1.4.
Okay.
You have another definition of deadly force under C.
I want to object to the record. The policy that the witnesses testified about is from 2017, and the policy that was in place may be very similar, but it has not been established that this policy was in place at the time of the incident. So it's testifying about something that's completely irrelevant.
I think this is the same policy that they were trained on. This is part of the training that was given to the officers at the time, so they can rely on it. So, this was back, I don't have the thing, this is 2020, that policy 2017 at the bottom, but this was also given in 2020. So this is still part of the same policy, and this was part of the training that was given to Officer Schurr through his career.
Yeah, there is policy from January 19, 2021 that came from GRPD. It may be very similar, but there may be differences.
But these are already admitted, Your Honor. These are already admitted, Your Honor.
Right, is that admitted as an exhibit?
It's already admitted as an exhibit, so
This one is the 2017 policy has been admitted.
Okay.
But
And so
it is
your
not-
objection
it's
is-
relevant. What does it matter?
Are you saying that the exhibit's not relevant?
But,
But it's
well,
not
I'm saying his
admitted.
testimony is not relevant. I didn't know the developments.
So his testimony about an admitted exhibit, I would think would be relevant because it's already admitted. To the extent that it's different, then obviously that would be something we can admit. If there's a newer, different policy, we can certainly move to admit that, but because was admitted without objections, it's
And
already
also,
in evidence, so.
if we could get some explanation for why this witness was not an expert on the GRPD policy, if it provided the basis of his opinions, then I don't know what that's going to establish either. That's more of a foundation.
that's what I just asked him. Or what?
That he's an expert on GRPD policy?
No, what role did this play in his decision?
Okay, so I'll allow him to answer that question. Maybe it didn't play any role because then that would be a kind of a moot point. So I just can answer that question, but again, I can't say that the exhibit's not relevant or that this witness's testimony regarding an admitted exhibit is irrelevant because we can only use the facts that are in evidence and information that is in evidence and the exhibit is in evidence. So you may answer that question if you're reasonable.
Could you ask that question one more time?
Just to say,
Sorry.
this was one of the things you reviewed as part of your analysis of this entire case.
Yes.
And looking at 3C, they talk about objectively reasonable control of the situation. Is that a term you're familiar with? It's 3C under 1.4.
Yes.
What does objectively reasonable mean to you?
That is the phrase in policing that is the generally accepted standard for police uses of force. They must be objectively reasonable. That language generally accepted in policing after policing adopted it from a 1989 Supreme Court case.
And so that's part of the analysis, not only for GRPD, but that's something that you're familiar with and use in your analysis of this case.
Yes.
Once again, looking at, now we're down to 9.15.
I'm sorry, what page are we on?
I've done the page, it's just policy 9-1.5.
Page 10 of the PDF? Or of the...
So in terms of the totality, you talked about the totality of the circumstances. What does that mean to you? And I guess how is it reflected? Is this, what's reflected in their policy reflective of what the totality of the circumstances mean in generally accepted police practices?
Yes. So totality of the circumstances here when you're analyzing use of force, it means you look at all of the facts and circumstances that the reasonable officer on the scene would have been aware of, the facts and circumstances that were available for an officer to observe and draw conclusions from. We want to avoid artificially limiting that because ultimately an officer should be basing their decision on the information that's available to them. And there's some information that is maybe potentially relevant, and there is other information that's far more likely to be relevant, right? So, for example, like the phase of the moon is not particularly relevant to a use of force. It might be relevant if it happened at night and we're talking about ambient lighting conditions. Ambient light is part of the totality of the circumstances. What I see this list of 1 through, it goes down to 15, as is a summary of relevant or potentially relevant factors that can make up, don't necessarily, because they may not be present in every case, but they can make up the totality of the circumstances that we review in determining the threat that the subject presents and whether the officer's use of force is proportional to it.
And so this listing here for Grand Rapids policy is also what is used out in the generally accepted police practices as well.
Sure. You don't always see it as a list. In our book, my co-authors and I provide a similar list. We break it up into 3 different aspects: a list of officer characteristics, a list of subject characteristics, and a list of environmental or situational characteristics. But they're all basically the same, right? I'm not saying like this exact list is something that you can find in every agency. But again, if you talk to officers at every agency and said, could this matter in the use of force analysis, they'll say, yeah. And there's probably stuff that's not on this list of 15 that could also factor in to the use of force analysis, like ambient light conditions, which are not actually on the list.
Why would ambient light conditions? That seems like kind of a random thing.
It depends on what an officer can see or can't see, right? How well an officer can actually see what's going on and what conclusions they draw from either good visibility or limited or bad visibility. That can definitely matter.
And that one thing, going back to the 2020 changes, going back to, I think, page 4,
Yes.
the things we can't put on.
Page 4, I'm there.
Was there anything about reasonable alternatives being exhausted before use of deadly force?
There is point 4 says require that all alternatives be exhausted before shooting, and the note is already in MOP 9-1 under escalation and de-escalation of force.
So all reasonable alternatives exhausted before shooting, is that a generally accepted police practice?
This one gets a little bit tricky. In most contexts, yes, but we have to be careful in how we define reasonable alternatives, right? In the context of a shooting, officers are presumably using deadly force to address a threat, as mentioned elsewhere in that policy, to address an imminent threat of death or great bodily harm. So we don't, when we're talking about reasonable alternatives, we're not asking, is there something else that officers could have done? We're asking, is there something else that officers could have done that would have had a similar likelihood of addressing the imminent threat of death or great bodily harm? So as long as we sort of define what we mean by reasonable alternatives, yeah, that's fairly common.
So ultimately, this comes down to the decision to fire on the cell phone video that you watched, correct?
Yes.
Can you give your idea? Was the decision with a reasonable officer similarly situated made that decision?
Objection, Your Honor? Let's see. Can we approach?
Yes. Thank you, you may be seated.
If I can just explain more of my objection, or maybe it's an objection to lack of foundation.
So you want
Can
to
I-
move more of the foundation?
Well, I don't even know.
That's an easy objection.
And I'm just confused, Your Honor. And the reason is, my understanding was that Opinion 7, Officer Schur's use of deadly force against Mr. Lyoya was unreasonable, excessive, and contrary to generally accepted police practices because he supposedly didn't know that there was a second, he did know the second discharge had been fired, and therefore he wasn't in fear of great bodily harm or death, and therefore was unreasonable. And he hasn't gone through that. He's just saying, well, do you think in general that this was excessive? And the report talks about why he thinks it's excessive.
I think the question was, would a similarly situated officer have made the same decision?
He hasn't talked about what the situation is yet. I understand that Mr. Bloomfield's going to testify about this opinion.
So then you just wanted to talk more about the situation?
Or which expert are going to talk about this situation? Because he suggested that Mr. Bloomfield is going to talk about the ones involving the taser, and this one does. And then Mr. Stoughton is going to talk about, I think, the foot chase and the failure to give a warning.
We can't say Officer Schurr did this. We've talked this over and over, that a reasonable officer similarly situated, in his opinion, number 7, Officer
You have
Schurr.
to direct me to the page, so I can.
This is page 63, 63 of this report. Officer Schur's use of deadly force against Mr. Lyoya was unreasonable, excessive, and contrary to generally accepted police practices. That's essentially what I asked him, except I didn't say, I can't say Officer Schurr, I have to say a reasonable officer similarly situated.
I agree with that.
And if he let me finish,
I'm sorry, Mr. Patrick.
I can, just because I'm starting out with that, and then I can say, can you explain why that is? He won't let me do that because, I don't have to do my direct based on what he'd like to hear first.
I agree, Your Honor.
Oh.
I'm sorry, but I thought Mr. Bloomfield was testifying about that.
Okay,
Because
so
this
we
is
can have
based on
the jury-
tasers.
Right, but
And-
you didn't ask him about a taser.
He's about to.
Well, you didn't, so you're objecting about something that hasn't happened. It's like, I don't know how I'm supposed to read this.
Well, because he's going to give his ultimate opinion about the taser before we've established that he's a taser
He
expert.
wasn't asking anything about it.
It's still part of his opinion. I cannot go into the decision. It's one of the things, but I don't have to get into his details of a taser. That's part of the whole thing. He's been testifying about the totality of the circumstances.
But you're okay with that question? You can answer that. The
Assuming-
question that you objected to.
Yeah, I assume he's going to go into the opinion number 7.
Is he going to go into opinion number
That's
7?
that's part of his opinion. Now, I'm not going into details with him, but that's part of the things, the basis. He did it jointly with Nick, and so they can say, okay, Nick is going to testify to that.
Okay. You don't have the jurors come back in. That was a short break for them.
What should I be able to voir dire Professor Stoughton on whether or not he's a taser expert? Because that's the basis of this opinion.
If he asks him a question that requires a response from the taser expert, then yes.
Okay.
But that question that he just asked, I don't believe does that. No. Welcome back. You may be seated. And you can repeat the question.
I will try to. Would a reasonable officer and a similarly situated reasonable officer made the decision to fire in this circumstance?
No.
Part of that, what is the basis for you? Is part of that going to the failure to warn?
No, failure to warn is a separate issue, right? A separate inconsistency with generally accepted practices.
So why do you mention that in your opinion in terms of this failure to warn?
I'm sorry?
Why do you mention that in this opinion in terms of your failure to warn?
As a separate opinion, there is like a tactical violation, right? There is some decision or action that is not in keeping with generally accepted police practices. Failure to warn prior to the use of deadly force is one aspect, but is separate and distinct from whether the use of deadly force was professionally appropriate. That is, you could have one without the other, right? You could have a warning where deadly force is inappropriate, or you could have no warning where deadly force is appropriate, or any combination.
What about the imminent threat aspect of it? The imminent threat in this situation, was there an imminent threat?
Not, in my opinion, one that justified a use of deadly force.
Why is that?
In order to justify a use of deadly force, it's generally accepted in policing that there has to be an imminent threat of death or great bodily harm. That is, the subject has to have, or to be entirely precise, reasonably appear based on the information available, have the ability, the opportunity, and the intention to cause serious bodily injury or death. In my opinion, that was lacking in this case.
So that leads to your conclusion in terms of the unreasonableness of the decision to fire. A reasonable officer would not have done the same thing.
That's correct.
One more, Your Honor. Thank you. I have nothing further.
Hello, Professor Stoughton.
Good afternoon.
Okay. I want to unpack a lot of what you said here.
Sure.
All right, so I want to, let's talk about your background a little bit. I believe you testified that you're a professor at the University of South Carolina.
Yes.
Okay. And you said you don't advertise?
As a consultant or anything like that, and that's correct.
Okay. But you do some marketing, right?
Not as an expert, no. I don't have a website or business cards or an email address or...
How about to sell your book?
Sure, I get the book was marketed, sure. I didn't actually engage in any marketing, but I know NYU Press did.
And in this case, you marketed your book based on the facts of this case in particular, correct?
I don't think I ever used any specific case to market my book.
Okay. Do you recall having an interview with Ken Coker from Channel 8 News?
Yes.
Okay, and that was shortly after this incident happened, right?
Yes.
And it was before you were hired by the county?
Yes, that's correct.
Okay. May I approach, Your Honor?
Yes, you
Let me show you the mark for identification as Defense Exhibit W.
Oh, you got my best face.
I'm sorry, I actually did try to get something decent, but and the reason that this is a picture of you,
Yes, it is.
and this is when you were giving an interview with Channel 8.
Sure looks like it, yes. That is not actually my name in the closed caption, but it's close.
Oh, I didn't notice that. Your name's not Self?
It is not Self.
Okay, well, closed captioning apparently got that wrong.
A little wrong.
Your name is Seth.
It is.
Okay. And this is a fair and accurate depiction, and maybe not the best likeness, but that is actually you in this picture?
Yes.
And Your Honor, we move Defense Exhibit W as evidence?
Is there any objection?
No objection.
Okay. And so shortly after the incident, you were asked by the news to go ahead and give some opinions of the video. Is that fair?
Yes.
And you did that.
Yes.
Okay. And in the background, you have a bunch of books, right?
I do.
Okay. And there's only one book that's forward-facing, right?
Yes.
Okay. And that's the book you've been talking about so far today, right?
Yes.
Evaluating Police Uses of Force?
Yes.
Okay, so it's fair to say you wanted people to notice that book.
Yeah, sure.
Okay. And I bought one of them.
You and 6 other people, so thank you.
We bought 2.
I get, and this is not a joke, I get about 3 cents per book.
I'm sorry to hear that.
Yeah, me
Well,
too.
you know, you should probably charge more on Amazon.
That is out of my hands. It's not that kind of book.
All right, but it's fair to say you're trying to sell books, at least in part, by putting it out there on the news behind you when you give interviews.
Sure. In my email signature, I have a link to my list of articles and to the book, right? Yes, I want people to be aware of the work that I've done.
Okay, and you can put that down. All right, so can you tell the jury what confirmation bias is?
Sure. Confirmation bias is the tendency, the human brain tendency to weight more heavily information that confirms pre-existing worldview and to devalue or weight less heavily information that tends to challenge your pre-existing worldview.
All right, so it's kind of like jumping to conclusions, or that's more expectation bias. Confirmation
It's-
bias, you've already made up your mind, and you don't consider things that come after. Is that fair?
Yes, that's more or less right. Confirmation bias is you, without being aware of it, which is why it's an unconscious bias. You interpret new evidence in a way that gives you more support for your beliefs.
Okay. And in this case, you were actually asked to form opinions based just on the video that you had saw that had been released by GRPD at the time, right?
Yes, in the news interview, I was asked to look over the video and talk about I think it was specifically sort of the sort of criminal or potential criminal ramifications of the act. I forget exactly how it was phrased.
Well, in the video, you said that it was your opinion at the time, shortly after the incident, that if there's a car with multiple passengers and one jumps out, that you should wave goodbye. The officer should wave goodbye as he runs down the road.
To the individual who's running away, yes, stay with the car. Stay with the individuals in the car, yes.
But should they actually wave goodbye?
I mean, that might be a little gratuitous. Should they, like, actually physically wave goodbye? No, but the idea is they should not go chasing that person. They should be staying with the vehicle to avoid putting themselves in a
That was just a little characteristic, uncharacteristic flair on, that's not a police tactic.
I don't know if I would
goodbye.
say uncharacteristic, but yes, that was clearly exaggeration.
Okay. But it's fair that you've already made up your mind about whether or not he should have stayed with the car based on that initial video way back when.
No, I think it would be better to say, as I pointed out in that interview, that the video is only one piece of many pieces of evidence. However, there is a tactical consideration here, and that tactical consideration does not change from having seen the video the first time to seeing the video and all of the other evidence.
Okay, so these tactical considerations, you just talked about how you considered the policy and everything like that, and you have since that initial opinion, it turns out you confirmed your initial opinion was correct, but you're telling us that you considered every aspect related to what could make this a bad tactical decision, right?
I'm sorry, so your question is, did I just confirm my initial opinions?
Well, yeah, I'm asking you about confirmation bias. Did you already make up your mind and you just found things that would confirm your initial opinion? Or did you actually set aside your initial opinion and start afresh and look at all these things you just told us you looked at when you're making your decision?
Sure. So to the extent possible, I have to set aside any previous review and review the totality of the materials that I'm provided with. When I do an interview, and I do a fair number of interviews with the media, one of the things that I always tell them, and it very rarely ends up in the story, is what I'm talking to you about is limited to the evidence that you're presenting me with, right? It's this particular video. But video never tells the entire story. If there's additional video, if there's additional statements that help explain what happened on video, what I'm describing based on this video may change because there's new information and different information. And that has happened in cases where I have both been retained and where I have not been retained, and additional information comes out and it changes an assessment of, or changes my preliminary assessment based on some evidence. In this case, what I think you're asking is the additional evidence did not call into question or lead me to draw a different conclusion about the specific tactical aspects that I talked about in that first interview.
Okay, except for the part about waving goodbye.
Again, that is, I think, perfectly appropriate in a news interview and is not something that is, part of an expert review. The idea that I'm communicating to a popular audience in a news interview is in colloquial language, right? It's in popular language. So yeah, wave goodbye definitely means let him go. It does not, in no way am I suggesting, and there's a reason it's not in my report now, that I'm saying you should quite literally lift your arm and give a little Queen's wave.
Okay. I didn't think you meant that. So when we talk about best practices, I mean, you've been an expert witness before. Is it a good practice for an expert to go on the media and talk about the case they're later going to be an expert in?
One, I don't use the phrase best practices with policing because I think that is too high a bar. What I'm doing as an expert is applying generally accepted practices, not best practices. With regard to your question, I don't know what cases I will or will not be retained in. I don't know what phone calls I will or will not get. I don't know what cases I will or will not accept. I don't know what cases I will or will not be useful. So yeah, I think it's entirely normal to have a media interview and then later get retained in a case. I think it's much more problematic to get retained in a case and then do media about the case, right? That I think is much more problematic, especially because you may be privy to information that is not public at that point.
And you haven't done that?
No.
Okay. All right, now, as you talked a lot about what you relied upon to form your opinion, and you talked about these generally accepted police practices.
Yes.
Okay. And that you basically, it's a conglomeration of reputable sources, agencies, practices throughout the country. Is that fair?
Sure.
Okay. You also indicated that you looked at GRPD policy,
Yes.
and you looked at GRPD training.
Yes, what training documents were included in the file, yes.
Okay. Are you an expert on GRPD training policies and procedures?
No, I would say the folks at GRPD are the experts about GRPD.
Okay, so they know it better than you do.
Sure. God, I hope so.
I hope, yeah. So are you familiar with the foot pursuit policy at the GRPD?
Not offhand, I don't remember. I think that was in the material. I don't remember if that was in the materials or not. I'd have to look.
Okay, so you don't know one way or the other whether or not GRPD trains their officers on conducting solo foot pursuits?
I'm not aware of very many agencies that don't that tell officers they shouldn't conduct solo foot pursuits. Definitely, there's often training on not doing solo apprehensions during a foot pursuit. But no, offhand, I don't know.
So certainly GRPD doesn't say to its officers, you can never do a foot pursuit.
I would be very, very surprised if that was the case.
All right, so let's talk about your opinion related to the foot pursuit.
Sure.
I think you indicated that no reasonable officer in that situation would have pursued Mr. Lyoya like he did.
Yeah, past the occupied subject vehicle, yes.
Okay. And so you were calling him Patrick? You don't know the family or anything like that, correct?
No.
Okay.
Or rather, yes, I agree with you. I do not know the family.
All right. So I think your opinion was the decision to chase by himself and away from a vehicle that he knew was occupied was unreasonable, tactically unsound, and contrary to these generally accepted police practices.
Yes.
Do you know whether it was tactically unsound and contrary to GRPD policy?
Again, offhand, no, and I'm not applying I'm not applying GRPD policies. I'm not trying to figure out whether he violated agency policy. I'm looking at whether he violated generally accepted practices.
Because you're not an expert in GRPD policy.
Correct.
And if we could, Mr. McFarland, I'm going to show you some of the video.
Sure.
Professor Stoughton. If we could go to RFA 3100 and exhibit 1, this thing without transcript, or A.
What was the RFA again?
3100. And for the record, I'm having Mr. McFarland put on the screen RFN, or RFN, Exhibit A, at RFN 3100 to 3560, which is from the time of the chase, basically, that we're talking about right now. And if you could go ahead and play it and stop it at 3560 or around there when it was made.
Stop. Put your hands down. Stop. That's it. Get one on it. Stop.
Okay. Stop there. So now we just saw an interaction between Mr. Lyoya and Officer Schurr that started with something that I believe you said was reasonable and turned into something that was unreasonable.
Yes.
The first part when he tried to arrest him, grab him, hold him, and not let him get away, was reasonable.
Sure.
It was a level of force that was commensurate with what he was seeing.
Yes, to the threat that Patrick or Mr. Lyoya presented, yes.
And the part that you're saying unreasonable is the decision to chase him
Yes.
after Mr. Lyoya broke away from him.
Particularly the decision to chase him past the occupied vehicle. As we know, and I apologize, I would absolutely butcher his name, but the passenger in the car gets out and starts filming shortly after that. The reason that running past is tactically unreasonable because if he got out with a gun and shot the officer in the back of the head, the officer would not see it coming, right? So that is one of several reasons why you do not do exactly what we just saw.
Okay. So now you are basing this based on generally hindsight, right?
No, that is another one of the biases that I try and avoid to the extent that it is possible, right, is hindsight bias.
You don't want people just sitting there watching the video, drawing an opinion in hindsight from the comfort of their chair, right?
So hindsight bias is specific and technical, like confirmation bias. It is the risk of interpreting the reasonableness of an action at one point based on the results of that action at a later point, right? So when I'm doing analysis, I try and be very careful to say I am reviewing the decision made at the time it is made without letting what happened later, whether it's good, bad, or indifferent, affect the reasonableness of that decision at the time. Excuse me, at the time.
So what you do is you try to, it's the reasonable officer on the scene, right?
Yes.
Okay, so you basically, what someone who had the knowledge and training of Officer Schurr, in this case, would have thought based on the situation that was in front of them at that moment.
Yes, the reasonable officer is sort of a construct, the reasonable officer in the actual officer's position.
Okay. Okay, so we have Patrick Lyoya, who is committed a felony by resisting and obstructing in Michigan. Do you disagree with that?
I'm not an expert in Michigan law or applying it, so I'm happy to accept your description of that, sure.
Okay. And are you familiar with the concept of resisting and obstructing in other states?
Yes,
Where were you a police officer?
Florida.
Florida? They have resisting and obstructing statutes?
Both a misdemeanor version and a felony version, depending on how it's performed, yes.
All right. And you saw, in this case, Mr. Lyoya break away from Officer Schurr.
Yes.
Okay. And that gives him the ability to run in the first place, right?
Sure. So you mean for like in the concept of threat, right? Like applying that those three prongs of threat. Is that where you mean ability?
Sure.
Yeah. I mean, not to be pithy about it, but right, he has legs and therefore has the physical ability to run. Yes, absolutely.
Okay. And you're saying the decision to chase him was unreasonable?
The decision to chase him in the context of this case, where you're chasing him past an occupied subject vehicle, where you have no idea who's sitting in that car, you have no idea what evidence is in that car, you have no idea what weapons are in that car. You are going away from sort of a, if not police controlled, at least police aware scenario, where you are standing at the car and looking at it, to now putting what may become an assailant at your back without even the ability to sort of keep visual contact. It's not the chase itself that's problematic, it's the context of the chase here and running past the occupied vehicle.
It's the continuing of the chase.
Yes.
Okay. So if we could look at RFN 3367.
What was that again?
RFN 3367. Okay. So this is not when the unreasonable decision was made, right?
No, I think, chasing him, it depends on where that chase goes. If the chase goes back behind the car, behind the police car, and keeps going down the street in the direction that Officer Schurr is facing there, you have the same problem. Don't chase someone away from an occupied vehicle.
Okay. So at this point, it's reasonable for Officer Schurr to make the decision to continue to try to apprehend Mr. Lyoya.
If he can do that in the context where he can keep visual contact on the car and not worry about an assailant approaching, especially undetected, sure, I think that falls within the zone of reasonableness. I also think it could fall within the zone of reasonableness to say, look, I'm not even going to scuffle with this guy, because if I do start to scuffle with him here and the passenger gets out and helps, I am immediately outnumbered, right? So again, I think the initial grabbing and this initial point is, you could, I don't think there is one path of reasonableness there for the officer.
And he's not scuffling with him, he's arresting him, right?
Well, no, not at this point. He was scuffling with him in an attempt to arrest him, but he was earlier grabbing him and trying to keep him from flee. I forget the first time he says you're under arrest or something like that, but I think it's fair to say that he is trying to prevent him from evading or escaping.
Arrest.
Sure,
He's not holding him for questioning, right?
I don't know what he's going to do, and if you mean arrest in the context of is he going to book him and bring criminal charges, I have no idea, right? That's a sort of mindset of the officer thing. He's definitely using force just before this to try and prevent the escape, which is, again, fine.
Okay. And RFN 3367 is, at this point, he's still within contact of the car. We don't know which way Mr. Lyoya is going to go. This is reasonable.
Sure, he's not chasing him, I don't believe yet.
All right, we're going to play it, and you tell us when it becomes unreasonable to chase him.
Right there for sure. As soon as it's clear that he's running past the car.
Well, his car is the gray one right there. You see that?
Yeah,
Do you think he's past the car?
I think he is running past the car, yes.
Okay. So
Because if
is the critical point, if he gets beyond the car, then you have to let him go?
The critical point is don't create a tactically disadvantageous situation by putting a potential assailant who has access to the car and everything in it that hasn't been cleared yet, that might have evidence in it or weapons in it or whatever. Don't put that at your back. So at the point where it looks like that might be what happens if I, the officer, continue down this course of action, yes, you should stop that course of action.
Okay, so he should have let him go at this point.
When you say let him go, he should have not continued to chase him on foot. He should have directed his attention to the passenger. That gives him a pretty high likelihood of identifying the guy who just ran away, assuming he hadn't identified him yet. And that means you can always go and get a warrant for him. So let him go. No, the law will catch up to him. It just may not be in this 5-minute period.
You're making some assumptions there, right?
Yes.
Like the passenger knows his last name, right?
Yes.
And that he has some ID, right? You're making that assumption that...
No, he doesn't have to have ID. If the passenger knows who he is, then you can start your investigation that way.
What if he doesn't know who he is?
It is possible that he gets away. But what is foreseeably likely to happen is you will probably identify him and catch him later. Now, might that not happen? Might he actually get away? Sure, that's possible. But letting someone flee from a traffic stop for an improper plate is certainly better than getting into a fight and losing, or getting shot in the back by an assailant that you couldn't keep an eye on because you are running away from an occupied suspect vehicle.
So officers should maintain visual or physical control over their operational space.
Yes.
Okay. And you would agree with me that Officer Schurr at this point does have visual control over the space?
Not for more than about half a second longer. So if he stopped there, I'd be fine.
Okay, so this is actually fine?
If he stopped there, I would be fine. The problem starts when he's running past the occupied suspect vehicle.
All right. And the concern is that the passenger is going to get out and jump on the officer, right?
That's one concern, right? There's also concerns about evidence that may be in the car that you may be losing because you're chasing the guy who doesn't have the evidence on them. There's concerns that the passenger may decide to slide over into the driver's seat and just leave with the vehicle, taking everything that's in the car away.
You're presuming that there's evidence in the car that would be interesting to...
We don't know.
Right.
Because he hasn't searched the car, we don't know what's in the car.
Right. And-
Right? We don't know that the passenger in the car is an assailant. We just know it's a potential. We do know that when you run past the car, it creates a vulnerability that you cannot tactically address.
Okay, so foot pursuits are inherently dangerous,
Yes.
okay? They're dangerous to Mr. Lyoya because he's about to be tackled, right?
Sure.
They're dangerous to police officers, and they're dangerous to bystanders.
They can be, yes.
Well, and this is a neighborhood, right?
Yes.
8 a.m., Monday morning.
Yes, thereabouts, yes.
Okay, people that flee are generally don't just run down the sidewalk, right?
I don't think there's any good data on that. It's running down the sidewalk. It can be cutting through yards. It can be going all which ways.
People that run can do dangerous things, right?
It's possible, sure.
Because they're not trying to get caught.
They're certainly trying to not get caught, yes. That's the running.
Sometimes they jump into other cars, right?
It's possible.
So you would agree with me that when Officer Schurr called in that he had one running, that he had made the decision to chase him?
Yeah, I think he does that as they're coming around the back of the car.
But you're saying that we faulted him because he should have stopped the foot pursuit.
Yes, rather than enter a tactically disadvantageous position, rather than create an avoidable tactical risk. Yes.
Okay. And you're not worried about the risk of Mr. Lyoya running into a house or a car?
Unless there is some specific and articulable fact to think that that's likely to happen, I balance that speculative risk against the speculative risk of getting attacked from behind by a passenger.
Well, keep playing the video, please. Yes, this is RFN 3480. And if you could play up to the tackle. Okay, if you could blow up not the one, thank you. This is RFN 3543. So where is Mr. Lyoya and Officer Schurr at this point? Are they on the sidewalk?
Near the back of that car, oh, thank you. Yeah, right there.
Okay, and so is it fair to say that Mr. Lyoya was headed towards the left side of the car and towards that house?
I don't know where he was headed prior to being grabbed because he
I just meant directionally.
he was heading down the sidewalk and then got grabbed, and I have no idea where he would have been going prior to that grab or not.
Okay, let's back it up and play it again.
So there's the grab. The grab happens right as they're entering that grass. So I have no idea if Mr. Lyoya was going straight along the sidewalk absent that grab, or if the grab is what pulled him to the side into the tackle.
Okay. So with regard to what you're considering, are you considering what the situation includes as far as what the officer knew at that point, just from the video? I'm not asking you to, based on an interview or something with Officer Schurr. What was known to Officer Schurr at the time he made a decision to not stop the chase?
I'm not sure I understand your question. So what does the video tell us that the officer knows without
So he knows
looking at
somebody's
anything
fleeing,
else?
right? Is there anything in the video that suggests that Officer Schurr knows who the driver is?
No, at that point I don't think so. I forget if Mr. Lyoya had identified himself or not. He had said, he had said something. He had said he had his ID or driver's license in the car and asked the other gentleman in the car to get it or look for it or something like that. But I don't remember if he had identified himself by name at that point. I don't think he had, but I'd have to go back and look.
So the video does not reflect that Officer Schurr knew who the person was that was running.
Yeah, I think that's right.
And you would agree with me, people run in order to hide something or to evade arrest. Is that fair?
Sure, all kinds of reasons.
Was there any explanation for why Mr. Lyoya shoved the officer to get away?
Any explanation
Yeah,
from
did Mr.
whom?
Lyoya, the passenger, or anybody say, hey, what are you doing, or anything like that?
I'm not sure I understand the question, I'm sorry.
Did you hear Mr. Lyoya say anything explaining his behavior?
No.
Okay, so the officer on the scene has no idea why this is happening.
Sure.
From that perspective.
Yeah.
And he doesn't know whether or not he's going to run into a house or not, right?
The officer does not know what is going to happen. Sure. But also has to base their actions on what specific and articulable facts they have to justify police action.
Now, you indicate that one of the things that could have happened by making this tactical error is the passenger could have got out and attacked Officer Schurr.
Could have, sure.
Okay, so that's one of the that's one of the reasons you let someone go.
One of the reasons that you don't expose a vulnerable quarter, right? Turning your back to someone in the car, yes.
Okay. And so we saw some interaction between Mr. Lyoya, and the passenger's name is Mr. Tuyasheme, but we can call him the passenger, if that makes it easier.
It would make it much easier for me, so I apologize.
Where Mr. Lyoya asked for his ID, you see Mr. Tuyasheme open a glove box and say that he can't find one.
Yeah, something like that, yes.
Okay, and then Mr. Lyoya is the one that shoves the officer and runs away.
Yes, certainly turns and pulls his arm. I don't know if it's like a shove push, but certainly turns and pulls away from the officer and flees, yes.
Okay, and so your concern there is not the person that just broke away from the officer, but the passenger?
The person who just broke away from the officer is not going to be in a position to threaten the officer. The person who is still in the car could be. So I am concerned as an officer with both of them, but I have a more immediate concern. So given the tactical risks and benefits of running past an occupied vehicle, I'm going to not do that. I'm going to stay with the vehicle, identify the passenger in the vehicle, and start an investigation to identify the person who just fled from my traffic stop.
Okay. So it's your opinion that no reasonable officer would have made the decision that Officer Schurr did, which was to not let Mr. Lyoya run an extra 7-8 feet.
It's my opinion that pursuing Mr. Lyoya on foot past the occupied subject vehicle is not tactically sound and is contrary to generally accepted police practices. It is not what I would expect a reasonably well-trained officer in that position, applying generally accepted police practices, to have done.
I just want to break that down a little bit, because I understand you're saying that you would not expect an officer to do that,
Yes.
but your opinion is that no reasonable officer would have done that.
No reasonable officer applying generally accepted practices relating to foot pursuits in this context would have done that.
Not a single one.
Not reasonably. If they did, it would be contrary to generally accepted police practices.
How about contrary to GRPD policy?
I am not an expert in GRPD policy, and that's not the standard that I'm applying.
Are you aware that Officer Schurr has been commendated for successful foot pursuits in the past by
Your
GRPD?
Honor, this was excluded before by the court, and now he just throws it out there.
I need to know what the basis of his opinion is.
Right, but he already stated what his basis was, so when it's the standard, that is the issue.
Okay. So now, in your, you have these 7 opinions. Is that fair in your report?
Yes, with some subparts for some of them, yes.
And I believe you opined on the foot chase,
Yes.
right? And you think no reasonable officer could have arrested Mr. Lyoya in that situation by continuing to pursue him, right?
Again, that's not exactly the way that I would put it, but I think no reasonable officer applying generally accepted practices would have chased Mr. Lyoya and put the occupied subject vehicle behind them, yes.
And then you also talked about that Officer Schurr failed to provide a feasible verbal warning.
Yes.
But it wasn't your opinion that the failure to give a warning meant that he couldn't use deadly force, right?
No, those are separate,
That's a totally separate thing.
yes.
Okay. And you just said that when feasible, an officer should provide a verbal warning prior to using force, including deadly force.
Yes.
And the normal context is, right, sort of a Tennessee v. Garner, police officers chasing someone down the road, and they're ahead of them, and police, stop or I'll shoot, right?
I mean, you probably don't want to shoot someone just for fleeing, but,
Well-
you know, drop the taser or I'll shoot, or, so, you know, it doesn't even have to be or I'll shoot, right? Drop it or you're going to get shot, something indicating this is the clear command, this is the threat, right? This is what will happen. This is the use of force that is about to occur, as a warning, yes.
Okay. And the International Association of Chiefs of Police indicate that a sufficient warning is you demand that the subject stop.
Sure, identify exactly what you want them to do.
Does it say, stop running, or is it stop running or I'm going to shoot you? Because according to the International Association of Chiefs of Police, which you hold in high regard, it's just that they demand that they stop.
I do hold them in high regard, and it is going to depend, but for someone who's just running away, stop running is fine, because you're probably not going to shoot them, right? Because someone who's running away is unlikely to just create an imminent threat of death or great bodily harm. When we're talking about deadly force, identifying, or any use of force, it is typically helpful for officers to identify this is the force that I'm going to use. That way you are informing the person, one, this is what I want you to do. Two, this is what will happen if you don't do what I want you to do. Put that down or you're going to get tased, for example. Very straightforward.
Okay, and so you're talking about, you believe it's generally accepted police practices that the officer has to give a warning, in other words, a condition of what happens if he doesn't comply with the directive.
Well, that's what a warning is, right? Telling someone stop is not a warning. Telling someone stop or this will happen is warning them of the consequence.
Telling someone to stop is a command or a directive, correct?
Sure, that's a
Right.
command, yes.
Okay, and do you recall what GRPD policy is on a suitable command before?
I think I still happen to have it in front of me. I can look it up if you want. I don't remember it offhand, but I can.
You have to give a directive before using deadly force. Doesn't say warning.
Sure, so that's not a warning, right? That's a directive or command.
Right, and so drop the taser is a directive.
Yes, definitely a directive,
So
sure.
you agree that Officer Schurr complied with GRPD policy when saying drop the taser?
Again, I don't want to hold myself out as an expert on GRPD policy, but if GRPD policy says directives are all you need to give, then sure, I suppose that is in compliance with policy. It is not in compliance with generally accepted practices relating to what a warning actually means.
Sure. Well, a warning, I would agree. There's some contingency that happens if you don't follow the directive.
Right.
GRPD policy says, and you just talked about it, whenever reasonably possible, officers shall provide verbal directives before deadly force is used. So you would agree with me that drop the taser is a verbal directive?
Sure. I have no idea how GRPD defines that directive. If they read into the word directive what I would consider to be a warning, I'm not sure, but that's why I'm not holding myself out as an expert in GRPD policies. But as a matter of generally accepted practices, if you're going to warn someone, what you're doing is you are threatening force, right? The warning is condition, threat.
Sure. That's your view of generally accepted police practices.
Yes, that is generally accepted police practice.
Do you have any idea whether Officer Schurr ascribes to your generally accepted police practices?
Well, I know he didn't in this case, but I'm not sure if he does generally.
Okay, but does he even know what they are?
I have no idea. I'm not in a position to identify what he knows or does not know, just whether his actions are consistent or inconsistent with them.
Well, you don't expect him to know every agency's policy in the whole country.
No, certainly not.
Okay. You indicated that the reason a warning was feasible or reasonably available and should have been given, a warning, is that Officer Schurr was in a position of tactical advantage.
Yes.
Okay, can we see RFN 7460? Mr. McFarland, when we're in our office, you hit right on the number every time, and we're here.
It's the big game.
And so you indicate that Officer Schurr is behind and on top of Mr. Lyoya, and therefore he's in a tactically advantageous position?
Sure. Now, I wasn't looking specifically at RFN 7460, but prior to him drawing the firearm, which I believe is already out in his hand at this point, yes, he is behind, over, partially upon Patrick, upon Mr. Lyoya.
And this is Exhibit A, just for the record.
Yes, Your Honor. So as far as the tactically advantaged position, though, if you don't have any feet or hands on the ground, and the person that you're on top of has both knees and both arms on the ground, do you believe that the officer is in a tactically advantageous position right here?
Again, I'm not looking at this particular frame.
No, I'm asking you about this one.
Right. If you're asking me about this particular frame, but my opinion that he was in a position of tactical advantage is not this frame specific, right? It is the events leading up to this frame. Is he in a position of tactical advantage? In this particular frame, he is off balance with his body weight, at least partially on, it looks like largely on Mr. Lyoya. In that way, he is not tactically advantaged. On the other hand, he is behind Mr. Lyoya, which makes it very difficult in this position for Mr. Lyoya to punch, strike, or otherwise direct an attack at him. In that sense, he is in the position of tactical advantage.
And
So
you-
it's not
I'm sorry.
perfect.
I didn't cut
It's
you off.
not perfect advantage. But even here, and certainly prior to here, he's not in that immediate position of being in physical danger.
Okay, and so you saw the video, and you saw Mr. Lyoya get up 3 times when Officer Schurr was behind him or on his back, right?
Yes, earlier when they were standing kind of behind where the passenger is now out
Sure.
and filming. Yes.
And you saw Mr. Lyoya bring Officer Schurr across the yard, right?
Yes, at one point on his back there were some knee strikes thrown in as Officer Schurr followed him across the yard, yes.
Now, and since we're talking about that, one of your opinions is that the intermediate use of force, when he was hitting the knee strikes and trying to punch him, those
Yeah.
were appropriate but ineffective.
They were, yes. There was an open-handed strike. There were 3, I think, knee strikes. The tackle itself, of course, is a use of force. Divorced from the tactical point that we already discussed at some length, I thought all of those as intermediate uses of force were perfectly appropriate and reasonable and proportional and consistent with generally accepted police practices.
Okay. All right, so you also gave the opinion that Officer Schurr's use of deadly force was unreasonable, excessive, and contrary to generally accepted police practices.
Yes.
And you didn't get a chance to explain why you felt that. And am I correct that the basis of that opinion is in the absence of any physical ability to incapacitate Officer Schurr or otherwise render him unable to protect himself, no reasonable officer in Officer Schurr's position could have concluded that Mr. Lyoya presented an imminent threat of death or great bodily harm?
Yes. Again, those 3 components of threat are ability, opportunity, intention. If you lack one of those, then there is no threat. There might be a risk situation, but there is no threat.
Okay, and you believe that the officer can use deadly force if the suspect reasonably appears to have the intent, opportunity, ability to cause a particular type of harm, in this case.
Can use deadly force, specifically ability, opportunity, and intention to inflict serious bodily injury or death. Absolutely.
Okay, and you consider the intent of the suspect when determining whether or not Officer Schurr acted reasonably?
It's more like I consider the perspective of the reasonable officer in Officer Schurr's position as to what the subject is trying to do. So it's not their actual intent. Who knows what their actual intent is? It's what does their behavior suggest
Okay.
to the reasonable officer they are trying to do.
So an officer who was incapacitated, and this goes to your opinion that deadly force was unreasonable, has lost the ability to protect themselves, including by preventing a subject from disarming them of their firearm and using it against them, right?
Sure. If an officer is incapacitated and stays incapacitated, they are incapacitated.
And here, you're worried about incapacitation because Mr. Lyoya has a taser, right?
I mean, I am not particularly worried about incapacitation, but that would be one way that you could establish an imminent threat if there was ability, opportunity, and intention.
Well, the opportunity here is a taser, right? That's what we're talking about in this opinion.
If, yes, I'm not entirely sure I follow, but yes, maybe.
Well, the basis of your opinion, that deadly force was unreasonable, is that in the absence of any physical ability to incapacitate Officer Schurr. When you're talking about incapacitation, are you talking about the fact that it's a taser?
I'm talking about the fact that there was no ability, there was no physical capacity for Mr. Lyoya to incapacitate the officer with anything.
Okay. So that includes a rock or anything else?
Sure, there are no rocks that I am aware of that he grabbed or had access to or had as a matter of physical ability, let alone intention or opportunity.
So would it be reasonable, therefore, that Officer Schurr, for Officer Schurr to use deadly force if he in fact held a reasonable belief that he was in risk of being incapacitated or tased?
Okay, so what I think I understand your question. What you're asking is the threat of being tased, does that create an imminent threat of death or great bodily harm, such that the use of deadly force is then justified? For that to be plausible, the threat would have to be the subject has the taser, which is in a condition to actually incapacitate. The subject, there is at least some reason to believe the subject knows how to use the taser, like disarming the safety and using it. That the taser, which is a weapon with a less than 50% effective rate, will be effective in incapacitating the officer. That the officer will remain incapacitated long enough for the subject to access a retention holster, and that the subject will know how to remove a firearm from a police retention holster, and that the subject will do all of that in the period of incapacitation, which is either 5 seconds with a taser pull or an unlimited amount of time, I suppose, until the battery goes dead if you're holding the trigger of the taser down, which means you're doing all of this one-handed. While I think it is at least theoretically plausible that that could happen, it seems unlikely, which might be why, going back to the history of the introduction of taser use, that has never happened in American policing or internationally that I'm aware of. So I think it is theoretically possible.
I'm sorry, did you say it's never happened that an officer's been tased?
No, an officer has never been tased, incapacitated, had their weapon removed, and killed with it.
Then why do you say in your report, it is well known and generally accepted in policing that an officer who is incapacitated has lost the ability to protect themselves, including by preventing a subject from disarming them and using the weapon against them?
That's still true. That is yes, that is absolutely a risk.
All right, so the concern here is that no reasonable officer thought they could be incapacitated, right?
Yes, in my view, that's correct.
Okay, and you're saying that a taser couldn't incapacitate the officer given the situation he was in?
Yes.
Okay. Were you here for Brian Child's testimony?
No.
Okay. If he said something completely opposite, would he be right or are you right?
Well,
That's an improper question. A witness can't comment on the truthfulness or rightness of another witness, especially when it's her reasoning. So it's an improper question.
I can rephrase it, you're right.
Right. So I'll sustain, but you can rephrase.
Okay. So you're an expert. You're not an expert on tasers, right?
I'm certainly a use of force expert, and
Sure.
within the world of use of force, taser is one of many weapons that are used. To that extent, sure. If you mean electrical engineer who can explain the magic that goes on inside a taser, no, in the same way that I really can't explain the magic that goes on inside a bullet to project it. I don't know what the chemical reaction is. I just know that it comes out of the muzzle of a gun, and I can, as an expert, talk about when it's appropriate to send it that way.
Are you in a position to tell when someone can be incapacitated by a taser? Are you an expert in that field?
As a use of force expert, sure, that's what tasers do, right? They are both pain compliance and motor disruption or physical disruption tools.
Okay. And in your opinion, when you believe that deadly force was inappropriate, you said the available evidence establishes that any reasonable officer in Officer Schurr's position would have been aware that Mr. Lyoya did not have the ability to incapacitate Officer Schurr because both cartridges of Officer Schurr's taser had been discharged.
Yes.
Okay. So it's your testimony that if both cartridges are discharged, he cannot be incapacitated.
It makes it exceedingly unlikely, especially with insulated wires. Yes. And there are a number of easy tactical alternatives. If you are worried about being subject to a drive stun, that is having the taser pushed against you, you just back up, and that deprives the subject of opportunity.
Okay. So you're not, you're saying he can't be incapacitated because the probes no longer are effective?
Well, the probes might be effective, but they're also laying on the ground, having been fired at the end of the wires that they're on.
Okay, and if somebody touches a probe, and then a drive stun hits them, they can be incapacitated, correct?
If someone grabs a probe and a drive stun is applied, assuming that the subject somehow knows how to do that, and assuming that the officer grabs a probe, sure, that can result in some type of incapacitation. Again, the response is don't grab the probe or back away from the drive stun to deprive of ability or an opportunity.
If I said grab, touch, the probes are laying on the ground in this case, right?
There are probes from where they initially fired, from where Officer Schurr initially fired the taser. There are probes somewhere by where they were scuffling on the ground. So there are probes out in that front yard, sure.
Okay, and you don't think that Officer Schurr should have done a probe check before in that situation, right?
Before shooting someone? I mean, if he's going to be worried about being incapacitated, yeah, I would certainly want him to know, is there a realistic threat of being incapacitated?
Okay, so if Brian Childs, and I'm going to represent to you that Brian Childs testified, that if you come in contact with a probe and someone drive stuns you, you will suffer NMI.
You can, sure. But there are two giant ifs there, both of which are addressable without the use of deadly force and addressable entirely with tactics, right? Again, assuming that either of those ifs actually apply.
And you talked about the drive stun.
Yes.
You're aware that the drive stun can cause serious bodily harm, correct?
It is substantially unlikely to, but it can, I suppose, when used in particular ways, in the same way that a thumb can be used to cause serious bodily harm when used in particular ways. But it is certainly not designed to and is unlikely to when used in any normal capacity.
Well, in a normal capacity is by a trained officer, right?
Usually, sure.
Okay. And you're aware that officers are trained never to hit anything in the face, right?
That, unless deadly force is justified, yes, sure.
How about if someone takes your taser? They haven't been trained, right?
Sure. That is correct. So again, one, there's some likelihood that they won't know how to use it. Two, there's some likelihood that even if they want to know how to use it, they aren't going to know to drive stun you, right, to push it into you. Three, if someone does know that somehow, you just build distance, which is a pretty core tactical concept, as a way to deprive them of the opportunity to use that taser in a drive stun mode. Any of those are sort of barriers to jumping straight from someone has a taser to deadly force.
Oh, and we're talking about whether it was reasonable to be in fear of incapacitation, right? And
I
you're
think
saying
so.
that it's unreasonable for Officer Schurr to think that he could be blinded by a taser in that situation.
You could be blinded with a finger or a thumb. It doesn't mean every time
Is
you
a
get into a
taser
scuffle.
a finger or a thumb?
To the effect when it damages the eye, I don't think there's a substantial difference. If you're talking about being blinded with something, then grinding a pen or dirt or a rock or your finger into someone's eye presents the same type of threat. It's a physical contact threat, right? So if that's, the drive stun has to make physical contact. The thumb has to make
So
physical
a
contact.
thumb and a taser have the same level of threat.
I'm not sure how you got that out of what I said. When you're talking about driving stuff into the eye, tasers present really no particularly elevated threat than jamming anything else into someone's eyeball. And it's certainly
You're
not
aware
the,
that a drive stun includes it's a tactical maneuver, but when you squeeze a trigger, an electrical charge comes out, right? You understand
Yes.
how a taser works?
yes.
And I'll represent to you that Brian Childs said that Officer Schurr was reasonably in fear of being harmed in that situation.
Yes, I'm going to have to object. That is not at all what Mr. Childs says. He didn't give an opinion on.
He did give an opinion.
Complete misstatement of his testimony.
Well,
This is-
the record will say what it says.
Right, it will, and I'll sustain that objection. Next question.
So it's your opinion a taser could not blind you more than a thumb?
I don't understand the question. Like, you're equally blinded whether you're blinded by a thumb or a taser.
Well, the issue here is incapacitation of a taser, because that's what you based your opinion on.
So are we talking about incapacitation or are we talking about being blinded? 'Cause
Well, you
those
said
are
pain
separate.
compliance is not enough to incapacitate, right?
Yeah, that's correct.
So if he had been drive stunned and not in the eye, then it's your opinion that that wouldn't cause sufficient pain to incapacitate the officer.
I mean, look, I drive stun myself every time I teach police law and policy when I teach a case on tasers. No, it's not incapacitating.
Well, it's not NMI, right?
That's correct. NMI is neuromuscular incapacitation.
You talked about the wires, and you said there's no reasonable fear of incapacitation because the wires are insulated in a way that even if he made contact with the wire, there's no risk of the taser causing any incapacitation.
So unlike some previous versions of the taser where the wires were uninsulated, if you got wrapped in the wires, you were going to go take a ride on the taser, right? With this version, they were insulated wires, and that is not a concern. If you need probe contact, not just wire contact.
So if the insulation had been scraped, or when it came out of the taser, had been ripped off in any way, that wouldn't cause a reasonable concern?
Sure, if there was any reason to believe that that had happened, sure.
And it does happen with tasers a lot, right?
I wouldn't say a lot, but what happened in other cases is not what happened in this case that an officer would have been aware of. Again, we're limiting ourselves to the facts reasonably known or available to the officer, the reasonable officer on the scene. And I don't see anything in the evidence that suggests any reason to believe that the taser insulation had broken, cracked, or stripped in some way.
Not the fact that they're being dragged on the ground?
No.
Do you know who Brian Childs is?
In vague terms, yes.
Okay. Do you consider him to be an expert in tasers?
I've never had to make that determination, so I don't consider him anything.
And you didn't consider any of his opinions about the taser before you rendered your opinions?
I don't remember when I got his report. I don't remember when I got his report. I don't want to be unduly offensive there, sorry. It's not that I neither consider nor not consider him, if that makes sense. Like, I'm not saying he's not an expert, I'm not saying he is an expert, I'm not saying anything about him.
Well, he was the prosecution's expert on tasers. Are you aware, do you know who he is?
Again, in vague terms,
Do
but
you know where he works?
no, not offhand.
He works for Axon.
Okay.
What does Axon do?
Axon makes, among other things, tasers.
Right. And he's worked there for decades.
Okay.
Would you agree with me that someone that's worked for Taser and Axon for decades would know more about tasers than you?
I think it depends on what they're testifying as. If he's testifying as a use of force expert, maybe not. If he's testifying as a mechanical expert on the taser, sure, he knows more than I do.
Right. Insulation on the wires, that sort of thing?
Sure, I suppose he could probably talk about the tensile strength of the insulation on the wires in a way that I can't.
And the ability to incapacitate an officer, right?
I don't see why he would know any more about that than I would.
Are you a master taser instructor?
No, I'm a use of force expert.
Okay. And so you think you know more about the ability?
He's arguing now, I don't know when this.
I want to explore what he thinks he knows and why he thinks his opinion is based on something other than his use of force. I mean, he keeps testifying that he knows about the mechanics of a taser.
Right, but you're asking him about a taser, but he's not a taser expert.
Right.
And he's a use of force expert. And so at this point, delving more into what one expert said versus what this expert is here to testify about, I do believe to be hard for him.
Okay, Your Honor, I understand that. I just want, as long as the court has acknowledged that Professor Stoughton's not an expert on tasers.
I consider him an expert in the field that he is considered an expert in.
Okay. Thank you, Your Honor.
I do, Your Honor. You guys, you've covered a lot of ground there, just in terms of, tactics is one of the things you talked about. Can you switch to our computer, please? And you talked about tactical advantage, and they showed up the cell phone video. This is that's theirs. Can you dim the lights too, please? You had an opportunity to take a look at the sequential images as well.
And this is,
Exhibit 6.
thank you.
Yes, I did.
Okay, starting at frame 3286. Can you give the jury a little bit of background? What do you mean by tactical advantage here when you're talking, I guess, in this specific instance?
Really, in this type of context, we're talking about does the officer have more control of the individual than the individual has over the officer? In this case, the officer has a number of weapons, both bodily and other, available. It's fairly difficult for someone in the position of Mr. Lyoya to attack the officer in this position. So, officer has more control over him than he has of the officer. That's tactical advantage.
Now, in terms of tactical advantage, does that go into your imminent threat analysis then, in terms of when you're trying to determine if a shooting was appropriate or inappropriate?
Yes.
And how does that factor in terms of imminence here?
So, again, when we're talking about imminent threat, even if someone has the ability to cause some type of harm, if they do not have the opportunity to do so, then there is no imminent threat of that particular harm. So if we go back to my hypothetical about someone with the tire iron, if someone has their hand on the tire iron, but the officer is, I don't know, standing on the tire iron in a position where the person can't use it, they might have the ability, but they lack the opportunity. There's no one vulnerable to that harm. Similar concept with something like this.
I'm just going to go through these frames here. Now they talk about at this point in time, clearly the officer's feet are off the ground, correct?
They are, yes. It looks like he's swinging his right foot over from the position where it was to the other side.
How does that change tactical advantage? Does that change it at all? Does it make it more or less?
I mean, the officer is not in what I would consider to be a particularly stable position. You don't want your weight to just ride on another person, because it means that they can take you in a direction you might not want to be taken. But in terms of attack, there's very, very little that Mr. Lyoya could do to threaten the officer in this position. They would have to get out of this position to create a position of opportunity for serious bodily injury or death.
Now, I guess we're moving along. You can see he's now the defendant's accessing his firearm at 3356. Has the tactical position changed at all at this point in time?
The officer is in a position of greater stability. Both feet, one knee are on the ground. At least one shoulder or chest area on the left side appears to be on Mr. Lyoya. So there's a less risk of unbalancing here.
Has anything changed in terms of the imminent threat aspect of that thing?
No.
3342. Has anything changed in either part? Are you trying to speed ahead? Is there any changes between either of them in terms of the tactical advantage or disadvantage?
I mean,
That's 34.2.
I'm sorry.
Again, there's clearly some potential disruption for balance, but in terms of basic positioning, no, not really.
What about now?
No, and no real change.
It's still the same tactical advantage or disadvantage you were talking about.
Yes.
Yeah, I guess I'm not going to go through the whole video. Did you ever see the defendant in any sort of tactical disadvantage through the entire, I guess, cell phone video?
No.
Thank you, John. Thank you. You talked about, they asked you some questions about committing a felony. He committed resisting opposing, he may have committed a felony. You weren't sure about a Michigan law, but resisting opposing is a felony in Michigan. Does committing a felony allow an officer to use deadly force?
No. In fact, there's a fairly famous line that's often taught in police training. It is not better for all felons to die than to escape.
So no matter how many felonies somebody commits, it doesn't mean that an officer is justified in using deadly force.
That's correct.
What about disobeying commands?
Again, absent an imminent threat of death or great bodily harm, no. Merely disobeying does not establish a justification for deadly force.
So you heard him, you didn't hear him today, but you heard him in the video. Patrick disobeyed, dropped the taser, stopped resisting, disobeyed numerous commands, correct?
Yes, he did.
Does that in any way change your analysis of the ability of an officer to use deadly force?
It's certainly part of the analysis, but no, it does not change the opinion.
Just because he commands them a bunch of times doesn't mean, okay, I can shoot him.
Correct.
And they talked about getting into the taser again. You said it's theoretically possible it could be disabling, but you said it's never happened. The officer's never been killed after being disarmed with his taser in the history of the taser.
That's correct.
All right, thank you. I have nothing further.
You're out of taser.
It depends on what you mean. If you mean taser as a use of force option and weapon, yes. If you mean taser in terms of am I an electrical engineer, no, obviously no.
Now, you talked about whether the officer has the right to use deadly force after a subject uses or commits a felony, correct?
I don't know that I talked about rights at all.
I think you just answered that question. Does someone have a right to use deadly force simply because they committed a felony?
I would not frame that in terms of rights. I don't think the question had anything to do with does the officer have the right to. As a matter of generally accepted practices, that is not a justification for deadly force.
All right.
But right sounds legal to me, and I'm not testifying on the stand as a legal expert here.
Okay. And you saw the videos. Did Officer Schurr pull his firearm after Mr. Lyoya committed the first felony?
I'm sorry, did he?
Did Officer Schurr pull his firearm by the side of the car?
Very early on. No. I don't think, no.
Okay. And he didn't pull his firearm when Mr. Lyoya refused to obey lawful commands, right?
Yes, at least not initially, yes.
Right, just the last one.
Yes.
And your final opinion about the use of deadly force is based on whether or not it was reasonable for the officer to be in fear based on the fact that whether or not he could be incapacitated. Is that fair?
I wouldn't put it that way. I would say my final opinion is about whether there was an imminent threat of death or great bodily harm.
Okay, and the threat in this case, according to your report, is that he was going to use the taser on him and potentially incapacitate him.
I think that's the argument, right? That's the argument that there was a threat, an imminent threat of death or great bodily harm because of the taser. Again, my opinion is there is no imminent threat, so I'm not sure that fully answers your question.
No, I think that I'm trying to figure out, we're talking about deadly force, and the prosecutor asked you a bunch of questions that don't really have any application here about using deadly force to arrest, or justified to arrest or an unlawful command. What we're talking about here is whether or not he was in fear of being incapacitated by the taser, right?
Whether there was an imminent threat of death or great bodily harm via the taser, sure.
Okay. Thank you.
Mr. Becker, anything else?
No, Your Honor.
I don't see any hands raised on the jury. May this witness be excused?
You may, Your Honor.
Any objection?
No, Your Honor.
Thank you very much, sir. You're excused.
Thank you, Your Honor.
Thank you, Coach. Is coming from out of town and is not in the building right now. So we're going to take our morning break for 15 minutes, which would be back at 3:40. And if there's a change, we'll let you know. So meanwhile, please remember, leave your notes upside down in your chairs. Continue to not discuss the case with each other or with anyone else. Also, you're still instructed to not access media regarding this case or social media. All right, and we'll see you back in 15. that's not, I expect the recording before, but that's not really 15 minutes. Okay, so meanwhile, we'll be in recess.
All right, please.
Thank you, Nancy.
Every time someone offers me some, I see it here in commercial middle school. That's one thing that I had told me. He rolled his own side down his own. Sit next to each other for a
Oh, yeah, constantly. It's the worst part about leave right now. Training for this.
Oh, really?
She has her own business. There's a spring sale. House married cops, most house married nurses. I'm married being great. It's good for me. It's good
Your witness ready?
He is not, still not here, Your Honor.
All right, is there anything we need to address before the witness is here?
Not from here, Your Honor.
For defense?
This time, Your Honor.
So, do we have ETA?
I told it 10 minutes, which was about 10, it should be pretty soon. Yeah.
Okay. So, I guess we can just continue or start back the break, because obviously there's nothing else to do other than have that witness come in, and if they're not here yet, I'll just wait here. So, we'll just go off the record meanwhile it gets here. Turn the record back on. So be seated. And Mr. Deputy, for the
Nicholas Bloomfield, Your Honor.
And sir, before you take your seat, if you could please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated.
Whenever you're ready, Mr. Deputy.
Sir, could you state your name and spell it for the record, please?
Nicholas G. Bloomfield. First name spelling is Nicholas. Middle initial is G. Last name spelling is Bloomfield. Bloomfield.
Could you tell the jury a little bit what you do for a living?
So presently I'm, where I reside is in Farmington, New Mexico. There is a nonprofit, community-owned hospital where I reside, and presently I am employed there as a regulatory manager, which means I'm responsible for making sure that the organization is in compliance with all federal and state regulations.
Was that your job years prior to that?
It was not.
What did you do before that?
Prior to that, I did a 20-year career in law enforcement in the state of New Mexico, was a certified officer. I retired in February of 2023.
And in terms of what roles did you have, what departments did you work for in the state of New Mexico?
So I worked for two separate agencies. I began working with the local sheriff's office. After completing the academy, I was assigned to the patrol division where I worked as a patrol officer. After a couple of years, I became a field training officer where I was responsible for training new officers and making sure that they were within compliance of both organizational policy as well as their training so that they could begin practicing on their own. Following that time, I made a transfer to the narcotics division. I did 3 years working as an undercover narcotics agent, where our primary responsibilities were to identify, infiltrate, and dismantle drug trafficking organizations. Following that assignment, I promoted to the rank of corporal. Short time later, I promoted to the rank of sergeant. I was assigned to the patrol division for both of those assignments, where I supervised officers who were working on a standard patrol shift. In addition to that, during my tenure at the sheriff's office, I was a SWAT team member. I did that for a number of years, approximately 6 years or so, and then I became a team leader once I was promoted. I worked at the sheriff's office for approximately 10 years, and then I transferred to our local municipal police department, Farmington Police Department. I went back to patrol there. After being on patrol for a short period of time, I assessed for the SWAT team, was selected to be an operator on the SWAT team. In addition to that, I also went into our training and recruiting division, where I was responsible for basic and advanced training. After that assignment, I promoted again to the rank of corporal and then to the rank of sergeant. As a sergeant, I was assigned to stand up a use of force investigation division within the organization. So myself and another supervisor were responsible for investigating all police uses of force within the organization. During my tenure, I reviewed approximately 200 cases. In connection with that assignment, I was also responsible for developing use of force policies and practices, as well as training related to the use of force. And following that assignment, I was assigned to a special task by the Chief of Police to reach out to and to work with academics in the field of criminal justice. Specifically, we were interested in conducting research related to a phenomenon known as contagious fire within the policing industry. Essentially, that's a situation where the question is when groups of officers are in a situation where they're applying deadly force through the use of their firearms, the question is that do officers fire rounds because they are viewing subjectively what they determine to be deadly force criteria, or are they shooting because other officers are shooting? And so again, the term that is used within the industry presently is known as bunt shooting or contagious fire. And so I was able to reach out to some academics and partner with them from the University of New Haven and conducted research. And so I kind of finished up my time working that assignment as well as a patrol sergeant before I ended up retiring in February of 2023.
Take a little breath there and grab some water.
Thank you.
You just landed from New Mexico too, didn't you?
I did. And I'm tired.
So I guess in terms of the use of force, primarily what you're here for, the use of force, how long exactly were you part of the training unit, if you will, for use of force with your department?
So assigned specifically to that role, I, again, did a number of iterations within the training division, both as just a training officer as well as supervising that division. Throughout that time, there was, so there's 3 periods of time during my career where I was specifically involved in training officers related to the application of force. And that ranges through all force options that officers generally have within the industry. Officers have a variety of force options which are available, and so they exist on a spectrum ranging from low-level applications of force all the way up to what we term deadly force. And so you have essentially empty hand techniques at a lower level of force, which is essentially is things to overcome low levels of resistance that an individual may be demonstrating, like resisting being placed in the handcuffs, resisting an officer's attempts to stop their freedom of movement, things of that nature. And in addition, going forward from that, there's another type of empty hands, which is kind of classified as like a hard hands, which would be like hard strikes. And those things are used, again, more for higher levels of force where a subject may be demonstrating combativeness or aggressiveness towards an officer. All those things together fall into a category of what is commonly termed in the industry as defensive tactics. And so defensive tactics, once you get out of defensive tactics, then you start getting into officers' actual tools that they have available. Generally speaking, the most common tools employed by policing within the United States are OC spray, commonly sometimes referred to as pepper spray. Then from there, you have a baton. There's different types and makes of batons, but essentially batons kind of fall under the same category. From there, you have electronic control weapons. The most common one within the industry is the taser, which is a proprietary electronic control weapon made by Axon. You also have canine deployments as well, where officers sometimes will use canines that are trained specifically to be used in force applications. And then in addition to that, you have deadly force, which is the most common form of, or the most common way that officers are taught to employ deadly force is through the use of their firearms. So again, these exist on a spectrum. And so in each one of these areas, I was responsible during my tenure as a use of force trainer and investigator to develop policies related to these things that are consistent with current industry practices and standards, as well as to develop a training curriculum for officers so that they could develop core skill competencies in these areas.
Now, in terms of training, did you only train officers in your New Mexico department, or have you been involved in training other officers as well outside of your department?
So since approximately 2007, I have in addition to practicing in law enforcement, I am a full partner in a training and consulting company, Progressive Combat Solutions. My partner is Kenneth Good. He's a former Navy SEAL. And we have trained thousands of officers, both at the state, local, federal level, all across the country, related to these areas, use of force. Primarily what we're known for is training officers in the area of tactics related primarily to generally what a SWAT team or a specialized unit would do within law enforcement. In addition to that, I've been retained by other agencies to assist them in use of force policy development, as well as teaching administrators how to review force applications within their agencies to make a determination of whether or not the actions of their officers were consistent or inconsistent with their organizational policies. And so my work has, again, taken me beyond just my local police agency that I work for.
Okay. And now in terms of when you talk about doing the different trainings, can you give an idea how many times, I mean, with your department, outside of that, how many different trainings have you done for various officers across the country? Ballpark.
I don't know if I could even ballpark it. Numerous, like I said, since 2007. I know thousands of officers. I would say less than 50, somewhere between 30 to 50 agencies. And again, when we conduct trainings on my specific CV, you won't see that many trainings outlined, but at these trainings they're typically regional, so we'll have officers that will come from up to a dozen different agencies that will send participants there.
Okay. Just in terms of, you talked also about doing use of force, like 200 use of force reviews. Were those use of force reviews simply for your department, or those other use of force reviews?
The 200 use of force reviews that I conducted were for the department, approximately 200. Outside of that, since 2020, I began having attorneys and police organizations reach out to me and ask me to review cases involving police officer force applications. To date, I've been involved in I've been retained in, I believe it's somewhere around 24 cases that I've testified in all across the country. And so, again, these are outside or beyond just my work that I did.
So, just so I understand, because the 200 were just within your department originally, and then there's 24 on top of that?
Yes, 24 where I was actually retained as an expert witness.
In terms of the 200, when you're looking at your department, what were you looking at for specifically when that was part of your job? What were you looking for in those instances?
So when you're conducting force reviews, I think it's important to understand that there's different types of reviews that are being conducted. When you are looking at an agency, you're essentially conducting a review to determine whether or not the officer's actions were consistent or inconsistent with organizational policy. And so that was my primary focus while conducting reviews for the Farmington Police Department. That's also what I trained other agencies to do as well. Beyond that, when you start getting beyond that, again, there's different standards that you could review a case. In my work as an expert witness, that review is essentially to determine whether or not the actions of an officer were consistent or inconsistent with generally accepted police practices.
Okay. And could you go into that? We've heard a little bit, but what are your definition of generally accepted police practices? How would you define that, and where does it come from?
So if you look across the country, there's approximately 18,000 police agencies within the United States, nearly 1 million officers. And so within the industry, there are generally accepted practices where essentially anywhere that you go in the country, you will see similar practices in the way that officers are taught to apply force, as well as the training that officers go through. One of the most common examples I could probably give you would be something like a traffic stop. It doesn't matter where you go in the country. If you see an officer conducting a traffic stop, the techniques, the tactics that officers employ are essentially going to be similar anywhere you go in the country. The way that this information gets disseminated across the country traditionally within the United States, this was done through just sharing trade knowledge. And so officers would essentially, through experience, begin to share trade knowledge with one another. Eventually, you had more legitimate trade publications that would come along within the industry that would share essentially this type of information. From there, you started to have expert bodies that began to opine on generally accepted police practices. For example, the most well-known and prolific entity within the United States is the International Association of the Chiefs of Police. They're over 100 years old. They're well respected within the industry, not just nationally, but internationally as well. They provide things such as model policies, as well as a number of recommendations related to training and standards that law enforcement agencies can adopt and utilize to make sure that they're operating, again, in compliance with generally accepted police practices. From there, you have other entities, including the Department of Justice. So the Department of Justice has an enforcement arm where they essentially are able to investigate police organizations where there have been complaints of essentially patterns and practices of unconstitutional policing conduct. And so the DOJ can go into these agencies, essentially conduct an investigation. If they determine that there are deficiencies by that agency, that again, they're not meeting generally accepted police practice, that would legitimize them as conducting constitutional policing, they will essentially sue them and can place them under consent decree. They always keep this stuff very transparent. You can go online and you can look up any of the consent decrees that agencies have been placed under. Where I did my law enforcement career in the state of New Mexico, Albuquerque Police Department was placed under consent decree in 2012. The interesting thing about the Albuquerque Police Department consent decree was, unlike other consent decrees in the past, this was the first time that the DOJ heavily cited use of force issues in policing, and essentially what they held Albuquerque PD accountable to was a signal to the whole industry that those standards are essentially what the DOJ considers the industry standard for constitutional policing as it relates to the use of force.
Okay. Now, I guess in terms of, does that, because you retired, you said you retired, and you were retired for a few years, and now you're doing compliance things with the hospital or a nonprofit hospital. Mm-hmm. Do you keep up to date then? Is that how you keep up to date, is right where you do consent decrees, or are there other ways you keep up to date in the use of force area since you kind of retired from a police officer as a police officer?
So I continue to stay up to date. I'm presently still practicing in law enforcement. There's a small agency within the area where I reside. It's named after me. It's the Bloomfield Police Department. It's not, but
they didn't name it after you joined.
No. But I am a reserve officer. And so through that, I still continue to practice. I volunteer my time and assist agencies, but also through doing work like this. I keep up to date, again, with the generally accepted practices through continuous review of trade publications. Like I said, there are trade publications that are used heavily in the industry. One example is Police One. They've been prevalent in the industry for many years. And again, that's a place where a lot of trade knowledge is shared. In addition to that, I continue to follow IACP as well as my colleagues that are also expert witnesses. We have essentially a large group communication where anytime there's new research or things that is coming out involving police standards or police use of force, we typically start a dialogue and see if that information impacts the way that we do this work. So,
at this time, I move for his admission as an expert in generally accepted police practices and use of force tactics.
An expert in generally accepted police practices, Ryan?
Maybe just police practices. I probably kind of got in my head. Police practices and defensive use of tactics.
I'm sorry. First you said use of force in police practices, but you meant
sorry.
You said you moved for his admission as an expert in use of force and generally accepted police practices.
Police practices.
And then you said police practices and tactical something.
In a long day. So just police practices and use of force.
Okay, any objections?
Limited to that, Your Honor. Can I ask a few questions? Can I invite you to the witness?
Okay. About his expertise.
Yeah, so just before I... Good afternoon. I understand you had a heck of a time getting here, so I appreciate, we were all wondering if you were going to show up with a suit and tie. So, we would have forgiven if you had showed up in jeans and tennis shoes.
Thank you.
So police practices,
Mhm.
you're an expert in police practices, not GRPD police practices, right? GRPD is Grand Rapids Police Department.
Say that one more time. I am an expert, I think I'm tracking, I am an expert in generally accepted police practices, yes. Specifically GRPD, I would say no.
Okay. And same question for use of force policies. You're an expert on the use of force in relation to generally accepted police practices, but not necessarily specific to Grand Rapids Police Department?
That is correct. What I will state, just to add a qualifier there, is that during my review of the materials in this case, I was provided the policies of the Grand Rapids Police Department related to use of force, and I determined that the policies of the Grand Rapids Police Department are consistent with generally accepted police practices.
Oh, all of them?
The ones that I reviewed, yes.
So you didn't review every single policy?
I can't recall right offhand every single policy I reviewed, but the ones that were provided to me.
Okay. All right, Your Honor, with that caveat, you may proceed, we don't object.
All right, then he shall be considered an expert in those fields of use of force and police practices.
All right, you were hired specifically to review this case, correct?
That is correct.
Do you recall approximately when that was, when that took place?
I don't recall it after
It's
first.
been a few years.
It has been a few years, yes.
What do you do when you get hired in to take a look at a case? What transpires? How do you start that review?
So generally speaking, all these cases involve some type of preliminary discussion where I'm essentially provided a brief synopsis of the case. There may be a discussion as far as where I provide my CV and what type of expertise I can offer. If an entity decides to retain me through a formal retainer, at that point I'm provided materials. Materials varies based upon the organization. I've had some cases, and again, sometimes this is just due to the nature of the incident itself. Some incidents simply consist of just reports by officers of witnesses, or there's no video, there's no additional information. Others, there's extensive multimedia in the form of video, audio recordings, things that can assist in the review. So it varies from case to case. But essentially, I rely on whichever entity is retaining me to provide me with the materials. I take those materials and I conduct an extensive review. My purpose in the review is to try to essentially determine what the facts are within the case. Once I have the facts laid out, I typically go back and to those who have retained me and essentially just go through to make sure that my understanding of the facts is consistent with their understanding of the facts, so that we're all on the same page. And then from there, I'll begin to formulate opinions based upon the actions of either a solo officer, or sometimes these incidents involve multiple officers. And as I work through these opinions, what I'm doing is I'm comparing again the actions of the officers to generally accepted police practice. And what I'm basically stating is whether or not the actions of the officers are consistent or inconsistent with generally accepted practice.
Now, you talked about some of the things you reviewed for this case. Some of the things that you did review would be the videos.
And that is correct.
What videos do you recall that you specifically reviewed?
There was a couple of videos. There was a video that was captured by the officers in-car camera. There was body-worn camera footage that was also captured by the officer's body-worn camera, and then there was cell phone footage that was captured by a bystander.
Okay. I'm going to go to, maybe start, I believe, switch it to our side. Try exhibit 2, please. Go to exhibit 2. You good ones, please. There should be a laser pointer right up there for your right. Now, in terms of, do you recall viewing this, would be People's Exhibit 2 at right about 2:02 of the time frame. Do you recall viewing this video?
I do.
This would be the in-car video.
It appears to be the in-car video, yes.
Now, in terms of use of force, you talked about some uses of force. I'm going to play this for you a little bit. Stop right there. Yeah, you talked about techniques. Now, the techniques here, what techniques did you see that were being used specifically in this instance?
So a couple of things here. When it comes to officers applying force, there's essentially two kind of categories. There are improvised techniques, which are essentially untrained techniques or techniques that an officer, where it doesn't mean that those techniques are not reasonable to be used, but at the same time, they're not necessarily formally trained, like in a defensive tactics setting. And then there are techniques that officers are generally trained in. So I see a combination of those two things. So let me give you an example of an improvised technique. If an officer is engaged in a foot pursuit, in order to terminate that pursuit, they may choose to essentially tackle the individual that's fleeing from them. I don't know of any law enforcement agency that trains officers to tackle formally because, again, the likelihood of injury would be too high in most cases. However, when you look at proportionality as far as the level of resistance that an officer is witnessing, that could be absolutely reasonable. It's just not formally trained. As far as what I see as being formally trained here, is the officer in this particular instance is applying some knee strikes. Knee strikes are a commonly taught defensive tactics technique within the policing industry. Knee strikes can be used defensively, so they can be used by an officer to essentially protect themselves if they are being attacked, but they can also be used to overcome levels of resistance. And so in this particular case, the officer appears to be in a position where he is essentially on top of Mr. Lyoya. In this particular instance, attempting to keep Mr. Lyoya down on the ground. Mr. Lyoya is clearly being successful in being able to rise to his feet. And so the officer is electing to use knee strikes in this particular case. It's difficult to see where those knee strikes are being applied. Generally, in order to overcome a level of resistance, knee strikes are generally taught to be used by officers to target essentially the lower extremities, like the thighs and those areas. Again, because it's not being used necessarily in self-defense in an instance similar to this one, it's being used to overcome that resistance. And so I see the application of a couple of knee strikes here, which appears to be targeted to the lower extremities.
And so that would be typical. There's nothing untoward about it. There's nothing wrong with that. That would be a typical thing that you would teach as a use of force.
Yes, based upon this video and based upon, again, the way that officers are taught this technique and how to deploy it, I would say that an officer in this situation, that this application of force would be reasonable and consistent with generally accepted police practice.
Maybe focus on a little bit more. I'm going to stop it here, Your Honor. Yep, this is Exhibit 3. I'm going to start at right about 2 minutes, I think. I can't read. 2 minutes. Now here, a little bit more focus on the hands. You can see the hands. Can you describe for the jury what they're seeing here?
So in this instance, the video appears to show that, again, Mr. Lyoya is down on the ground. He's attempting to get to his feet. The officer is on top, attempting to control him. So it's common within the industry that officers are taught defensive tactics related specifically to working with individuals on the ground who are demonstrating resistance. Again, you have two different areas on the spectrum. One is to overcome resistance, the other may be defensive. So recently, within the last, since I've been in law enforcement over the last 20 years, grappling, jiu-jitsu, those techniques have been heavily adopted within the policing industry all across the United States. The comprehensiveness of an officer's training in that area may vary, but at the same time, officers are taught grounded techniques of how to control subjects who are resisting, as well as how to actually defend themselves if they find themselves under attack, well grounded. Here in this particular instance, everything that you see in terms of hands being placed to attempt to keep Mr. Lyoya on the ground, I would classify this as essentially, again, just techniques that officers are generally taught. A little bit of improvisation also appears to be occurring here, but the positioning and everything that the officer is attempting to do, again, I would state that an officer in this instance, that all of these applications of force in an attempt to keep Mr. Lyoya on the ground would be reasonable and consistent with generally accepted practice.
Now, we're going to move along a little bit. At some point in time, there's a taser introduced. Is that a fair statement?
Yes.
I think we're still in Exhibit 3, right? Okay, there's a taser introduced. Could you give the jury a little bit in general, in training and generalized general police practices? When do you introduce a weapon? When is there any criteria? Can you give a jury an idea of what goes through that?
So, as I briefly talked about during my initial questioning, officer use of force exists on a spectrum, and so officers have many force options that are available to them to overcome resistance. I need to talk just a little bit and lay a little bit of a foundation in terms of how an application of force, what essentially allows an officer to make a decision from going from a lower level of force to a higher level of force. So the first thing is proportionality. And proportionality, we primarily first want to talk about levels of resistance or aggression that may be exhibited by an individual. So when an officer has essentially a valid legal reason to detain an individual, whether that is to detain them to investigate a crime or to detain them, essentially taking them into formal custody, if an individual resists the officer's actions, the degree of resistance that they exhibit is what opens up the options related to an officer's use of force selections. And so at the lower end, if an individual is displaying a low level of resistance, maybe they're passively, or they're walking away, from the officer after the officer's told them that they're not free to leave, or they attempt to lay hands on an individual, tenses their arms, flexes, pulls away, things of that nature. That would be low-level resistance. And the thing is, again, I think it's important to understand that the term resistance is key. Resistance does not suggest that an individual is trying to harm the officer, but they are simply, trying to resist an officer conducting a lawful objective. And so from there we get into what would be constituted as aggression, where somebody is actually physically trying to harm an officer. Harm can come in all different ways. Physical assaults, an individual could attempt to use a weapon on an officer, things of that nature. So then when you get into that area, now we're looking at much higher levels of force that would be appropriate to be used. And then eventually we'll get to the application of deadly force. In this particular instance, so when electronic control weapons, and this is a Taser 7, this is the same model of Taser that I carried towards the end of my career. The Taser, when it initially arrived and became prolific, it was in the early 2000s roughly, and it became more and more common within the policing industry. The Taser has a couple of different options available with it. So first and foremost is the proprietary nature of the Taser that Axon developed was the Taser was capable of achieving what is known as neuromuscular incapacitation, or NMI. Essentially, NMI, if you've ever seen somebody actually be tased with the Taser, it manifests that NMI has been achieved by watching somebody essentially lock up, where essentially they've lost motor control for the period of time when they are under a cycle of the Taser. And again, this is going to get a little detailed, but it's important I have to again lay this foundation so we can understand when the Taser would be appropriate to be used and where it kind of lies as a force option.
Objection, Your Honor. This is all about expertise in tasers, and I don't believe you've been qualified as an expert in tasers.
It's not about tasers, it's about what you just said, when the tasers are appropriate as a use of force option. So he's trying to talk about when a taser can be introduced. He's not talking about the specific instances of a taser, it's just when it should be introduced in the spectrum of what an officer has.
Okay, so I'll overrule the objection because I do believe he's testifying about it in the use of force context. You may answer that question.
So yeah, just going into it in terms of, trying to get into how is it determined appropriate when you have other options, baton, OC spray, taser.
So going back to the Taser, so the Taser is capable of achieving neuromuscular incapacitation, or NMI. In addition to that, it also has the ability to not create NMI, but essentially operate off of the principle of pain compliance in what is commonly referred to as drive stun mode. So if you essentially remove the cartridge or the multi-cartridge from a Taser, this particular model of Taser has multiple cartridges. There are essentially probes that are on the end of the Taser, where essentially you can contact somebody with that, pull the trigger of the Taser, and it'll cycle. This is not achieving neuromuscular incapacitation. This is just achieving pain sensation, and so it's known as pain compliance. OC spray also operates off of the principle of pain compliance. And so when an officer applies OC spray, it's essentially you're relying on how susceptible the individual is to that burning sensation in terms of how effective it's going to be. So you may have individuals that are sprayed with OC spray where it's highly effective. You may have individuals where it's as if nothing happened. And so just wanted to clarify that those are kind of the two different ways that this tool can be used. There's kind of a third one, which I won't get into. But essentially, at the lower level, because drive stuns operate off of the principle of pain compliance, that is considered a lower level application of force than a full probe deployment. So when an officer actually has a cartridge attached, there's two probes that fire out of the end of the cartridge. Those probes, if there is a successful spread in those probes, that's the highest likelihood that NMI may be achieved. And again, it's not always a guarantee. There's a variety of things that could happen that could impede NMI from actually occurring. But when you see an officer deploy the taser in probe mode, the goal or the intent is that NMI is going to be achieved through that. And the other thing is that what probe mode allows you to do versus drive stun mode is you can actually attempt to energize a subject from a distance. Okay, depending, these cartridges come in different lengths, and so you have 21-foot cartridges. You can get longer cartridges, which are sometimes used for specialty situations. So again, going back to when it is appropriate. So an individual that is demonstrating active resistance towards an officer. Now, here's where I'm going to talk a little bit about differences in industry standard. There are officers throughout the country which train officers, and it is also within their organizational policy that a drive stun can be used to overcome lower levels of resistance, again, operating off the principle of pain compliance. When it comes to the actual application of the taser in probe mode, again, that can be used for higher levels of resistance. And in this particular case, what makes this decision of the officer to deploy the taser appropriate is the fact that the officer, has already used other lower levels of force in the form of what we've already seen, empty hand techniques, trying to keep Mr. Lyoya on the ground, knee strikes, things of that nature, and those things have failed. And so there is a principle in policing where if a lower level of force, and this is generally going to be within the spectrum of all levels of force that are less than deadly force, that if those levels of force fail and the individual is continuing to display resistance, the officer can escalate their application of force, which appears what is happening in this particular instance. And so, again, an officer in this case choosing to deploy a taser in probe mode, although I would say that the method of deploying it is tactically unsound, but the decision to actually utilize a taser would be consistent with generally accepted police practice.
In terms of you talking, are OC spray and taser? You talk about the same thing. Are they on the same level? I guess of force.
They are not. They are not. But again, let me clarify that when you talk about the taser being utilized in drive stun mode, not in probe mode, the drive stun mode, because it operates off the principle of pain compliance, could be categorized essentially alongside OC spray in that sense. Generally speaking, tasers are considered a higher level of force application because the intent of the manufacturer, as well as the opinion of expert bodies within policing, a probe mode deployment is considered a higher level of force on the spectrum than OC spray would be.
Okay. Now you mentioned though the decision made to use the taser is appropriate within the spectrum, but tactically there's an issue here. What do you mean by that?
So when it comes to the application of force, but also when it comes to police activity in general, police throughout the nation are essentially taught tactics. Tactics fall under what we generally categorize as officer safety. And so essentially officers are taught in the basic academy, and this is consistent all across the industry, where officers are provided common tactics of how to safely go about accomplishing their lawful objectives. I mentioned traffic stops earlier. Everything that an officer does, from the positioning of their vehicle to where they choose to make a stop, if it's within their power to do so, to the way they approach a vehicle, that is all done with purpose and intent. And it's done so to not just protect the officer, but also to protect the individuals that they're contacting, as well as other bystanders that may be in the area. Essentially what we talk about when it comes to police working and accomplishing their objectives, there's always risk involved, right? There's always risk involved in this type of work. However, through sound tactics, if officers rely upon sound tactical principles in the way they go about conducting their work, they can prevent risks from manifesting as threats, and from threats, if there is a threat present, potentially manifesting as harms to the officer or others. And so again, tactics are very key in this whole conversation about the application of force. So in this particular instance, the issue as far as, well, the selection of the taser was an appropriate selection and an appropriate option at this point to overcome the level of resistance that was being demonstrated by Mr. Lyoya. Officers are taught within the tactical arena as well as in defensive tactics something that we term weapon retention. So weapon retention is a key principle where essentially if you're going to employ a tool on an individual, part of your calculus in choosing to deploy that is you also want to make sure that that tool cannot be taken from you and potentially used against you or others. This is really prevalent when it comes to police firearms. There are many case studies out there where officers have been killed with their own firearms, have been successfully disarmed. This also applies to every other force option that an officer has at their disposal: OC spray, baton, taser, etc. And so officers are taught techniques and tactics to essentially retain and keep their weapons. In this particular instance, there's two things about the taser deployment here. If the taser is going to be deployed in probe mode, the manufacturer, and this is common in, because the training that officers receive as far as as taser goes is consistent throughout the industry, because taser actually provides the training to police agencies. And so according to taser themselves, in order to have the greatest likelihood that when the probes are deployed that you're going to get a far enough spread apart and get what they essentially term splitting the hemispheres, which is where you have a probe, the belt line, you view the waistline as the hemisphere, having a probe, one probe above and one probe below in large muscle masses is going to give an officer the highest likelihood of achieving neuromuscular incapacitation. In order to get that spread, you have to have distance between you and the target. And so generally speaking, that distance, again, needs to be, what taser recommends, roughly 7 yards to get that accomplished. So two issues here is deploying a taser this close when the environment does not force an officer to have to deploy the taser this close, meaning that in a confined space where the environment precludes an officer from being able to create space to do this, that's one thing, but that's not this particular instance. The officer has the ability to create distance. And
Let me stop you right there real quick.
Yes.
And I just want to get into that distance aspect. Is distance only with the taser, or are there other things in police, defensive tactics where distance is important too?
So distance is always important. It is one of the largest factors when it comes to these type of confrontations. Time and distance are the two biggest factors. So we talk in policing, it's not always about creating distance, it's about creating the right distance. Sometimes the appropriate answer is to close distance. Sometimes the appropriate answer is to create distance. Depends on what the force option is. It depends on what the situation is. Officers are also taught that if they are in a situation where they're applying force, and generally this happens solo, if they are unsuccessful in overcoming an individual's resistance, and they are essentially failing to overcome that resistance, sometimes the best option is what we refer to as a tactical retreat, where we create more distance, we keep eyes on, we summon more resources. That could be an option. The other thing is if an officer is being attacked, if they have the ability to create distance, they can do so. And so again, it's multifaceted in terms of what may determine that.
So then so going specifically for this instance, so it's distance not only for the taser, but there's also distance just in general for police practices.
Correct. And so in this case, by creating distance, that would allow two things to happen. One would be there'd be a higher likelihood that neuromuscular incapacitation is going to be achieved because now we're at a appropriate standoff distance recommended by the manufacturer that's going to give us the greatest likelihood of achieving NMI. Number two is I'm also, by creating distance, I am preventing anybody from grabbing a hold of the taser, so that's also the best option because it's the most tactically sound option. And so that's why the failure to create distance in this particular case is tactically unsound, although the decision to employ the taser was reasonable.
So disengagement is part of police training. Is that part of police training and generally accepted police practices?
Yes, it is.
It's not a matter of you being a coward or running away or, you know.
No, what we find statistically speaking, again, is when an officer essentially is in a situation, and again, it depends on the circumstances, right? So let me qualify this by making the statement that the highest priority that American law enforcement has is the protection of life. That is the highest priority. So if you have a situation such as an active shooter, an active killing event, officers are taught to close the distance immediately with haste to essentially locate pressure and stop the action of the shooter or whatever it is that's preventing imminent threat of harm to life being lost. That just doesn't fall on the part, that just doesn't mean officers, that also means bystanders. In addition to that, officers are also concerned about preserving the life of the individuals that are resisting them, that they're attempting to take into custody, or that are involved in some type of law enforcement action. And so what we find is that, again, because we have enough data points within the industry and enough experience within the industry, we know that sometimes a tactical retreat is actually the safest option for the officer. It's also the safest option for the suspect. It's also the safest option for bystanders. And again, sometimes you get into a situation where, you know, for lack of a better term, you may be in over your head where you don't have the resources to safely do this alone. Foot pursuits are a big example. It used to be in the industry that you know, foot pursuits were very commonplace. Officers would take off solo, and we had a lot of instances of officers being seriously injured or killed, as well as suspects. Now, the generally accepted practice, and again, this has been recommended by all kinds of expert bodies. It's very common within the industry. The officers need to make a good tactical decision as far as when to pursue and engage in a foot pursuit, particularly solo. That would depend on the nature and severity of the crime. Sometimes it's just not worth it for low-level crimes to initiate in a pursuit, especially where officers may be placed in greater jeopardy by initiating that pursuit. Officers are taught as another option to essentially keep eyes on, continue to follow from a distance, but to summon other resources and essentially close in and wait till other resources arrive. And again, what we find in those cases is a reason why that direction has changed in the industry is because we find that officers, suspects, and bystanders are safer as a result of that type of disciplined decision-making.
Can I actually see it's 1:45, I can see the clock, so.
Yeah, so we're going to stop here and resume tomorrow morning at 9 a.m. And so meanwhile, jurors, please again leave your notes upside down in your seats and remember to not discuss the case with each other or with anyone else. And also avoiding media reports about this case and
Just one thing, Ryan, I know the defense is sorry for the whittled their witness list down. I got a 47, but they said now it's a dozen. I'm wondering if I can get a copy of who the witnesses would be, so they're going to start their case tomorrow.
We're still considering things, Your Honor. We'll give Mr. Becker a list tomorrow with to exclude.
I got to be tomorrow with, how do I prepare for cross-exam if I don't know who's testifying tomorrow?
We're going to start, we'll let him know tonight who we're going to call, the first 3 or 4.
We give them an amended release list this evening.
And if we could, we'll give them the ones we're going to call first, but prepare.
Okay.
But the ones later, there's like some flexibility on it. And my understanding is the expert is still under oath, and Mr. Becker still has more questions, correct?
That's correct.
Okay. All right, anything else from Mr. Becker?
At this point in time, Your Honor.
For defense, anything else before we recess for the evening?
Very well, thank you.
All right, well, I hope everyone has a good evening. See you in the morning.
All right, please.